We'll start the proceedings of the evening. We have an array of wonderful panelists, and it's my privilege to introduce each of them one by one in front of this august gathering. I start with the senior most, Mukul Saikia sir. He has been a Superintendent of Police, retired now from his services, and is known for his distinguished career in law enforcement in Assam. His extensive experience in policing includes handling high-profile investigations, ensuring public safety, maintaining law and order across various districts. He has played a pivotal role in combating organized crime and ensuring justice through effective legal enforcement. He has been recognized for his leadership and commitment to public service, having worked in several challenging assignments throughout his career. A couple of famous cases associated with the tenure of Shri Saikia. So one was a social welfare scam that he had led an investigation into a massive scam in Assam Social Welfare Department. His inquiry reached an advanced stage, and several prominent figures, including former ministers and high-ranking officials, were under scrutiny. However, his sudden transfer raised suspicions as it occurred just when the charge sheets were being prepared. The other sensational case was the APSC corruption case. Most of us are well read about it, perhaps. He played a key role in probing the disproportionate assets of the then chairman of APSC. He submitted a detailed report recommending further investigation, which led to his transfer from the Vigilance and Anti-Corruption Bureau. The Gauhati High Court later ordered his reinstatement, acknowledging the importance of his role in the case. His work in investigating these and other sensitive corruption cases gained him a reputation for diligence, though it also attracted political challenges leading to transfer. Can I have a huge round of applause for our guest today evening, our panelist, Shri Mukul Saikia sir. Bouquet of sweet-smelling flowers, sir. And of course, a Rabha Gamusa, Tapazar. And there's Shashank felicitating him with the same. The next guest that I have my privilege of introducing is Professor Sarfaraz Ahmed Khan. He's currently serving at West Bengal National University of Judicial Sciences as Associate Professor. Prior to this, he was teaching at Maharashtra National Law University as Associate Professor and Professor and Director at Symbiosis Law School, Hyderabad. He has almost 2 decades of experience as a law teacher and as a researcher. He's involved in researches intertwining the criminal justice administration, human rights, and human trafficking. He has authored several books on these subjects, the latest being the Transnational Sex Trafficking and Integrated Reparation Model, which emphasizes on human rights dimension of cross-border sex trafficking between India and Bangladesh. His edited books include Groundwater Law and Management in India, From an Elitist to an Egalitarian Paradigm, edited jointly with Tony George Puthucheril and Sanu Rani Paul, Uniform Civil Code, A Never-Ending Dilemma in India with Ahmar Afaq, Consumer Protection and Sustainable Consumption with Dr. M. Rajinikanth. Mr. Khan has also authored several research articles in journals of national and international repute and presented papers in several national and international conferences. He has also developed numerous training manuals and study materials and has imparted training to several functionaries of the criminal justice administration in India, including the police, prosecutors, and judges. Amongst the innumerable accolades and scholarships awarded to him, Mr. Khan has been bestowed with the British Chevening Scholarship to pursue second LLM in International Human Rights Law from University of Essex, Hong Kong UGC Scholarship to pursue PhD at City University of Hong Kong, Michigan Grotius Research Fellowship from Michigan Law School, USA, and the International Visitors Leadership Program Fellowship by Department of State, USA, and Anti-Human Trafficking What a stellar career, sir. Welcome to Guwahati and welcome to this evening's panel discussion. Satirtha Saha, sir, to kindly come and felicitate Mr. Sarfaraz Khan. The next guest that I have the privilege of introducing is Shri Angshuman Bora, who is known for his distinguished legal career. With years of experience in the field of law, he has earned a reputation for handling a diverse range of cases, including constitutional law, civil disputes, criminal matters, and public interest litigation. His expertise, persuasive advocacy, and in-depth knowledge of the law, especially criminal law, has contributed to his prominence in the legal community of Assam. His handling of many sensitive cases has highlighted issues related to today's topics under discussion, like human rights, personal liberty, effective means to justice. He has frequently interacted with the society through mass media on issues that have seized the concern of wider civil society, namely crime detection, protection of civil liberty, access to timely justice. In addition to his legal practice, Mr. Bora has played an instrumental role in mentoring young advocates, shaping the next generation of legal professionals. His commitment to justice, ethical approach, and sharp legal acumen has made him a respected figure among the legal fraternity and wider society. Was there an extra ounce of excitement when I was introducing Angshuman Bora? Well, I could be excused for that because this is one person, a dear friend, my classmate, who keeps making us immensely proud. Angshuman, it's my privilege to introduce you today evening and requesting Janali to kindly felicitate him. And now I would like to introduce Shri Parikshith Kutur. Advocate Parikshith Kutur, partner at Pramana Law Chambers, is a passionate lawyer crafting legal solutions. He practices in various courts in Hyderabad for matters concerning civil, criminal, and writ litigation across different forums. During his more than a decade of practice as an advocate, Advocate Kutur has acquired a rich experience in civil and criminal cases relating to writs, revenue, land, service laws, public interest litigations, company laws, and trial matters. As a practitioner, he has developed a keen interest in developing systems towards access to justice for all. Thank you, Mr. Parikshith Kutur, for taking time out for joining the panel today. Kindly put their hands together once again. Put your hands together for all our panelists. It's a stellar panel today, and we cannot have this stellar panel without a stellar moderator. And therefore, my privilege of introducing and calling upon Mr. Pankaj Das, the moderator of today's event, to today's panel discussion. He's a president of Indian Policy Institute and has spent almost all his working life in social sector, working with schools and NGOs. I think the dais is all yours, Pankaj. Handing over the proceedings to you. Thank you.
Thank you, Mitra. And thank you, everyone, the panelists and the audience. Thank you for coming here, being here this evening. Let me ask you a rhetorical question that why we are organizing such workshops. As it is there in our as our mission, that we bring together academics and practitioners to the citizen. Because we believe the situation that we are in today is mostly a demand-side problem. The demand is not there. The suppliers are not going to give us unless we demand. We know, or at least arguably, we know our problems, and again, arguably, we know our solutions. But as the Introduction to Justice Molimoth Committee report, they quoted a French thinker and writer, André Gide, and that quote is, "Everything has been said, but since no one listens, we need to say again. So, quality-wise, we may not know all the answers. For example, I'll just cite 3 examples. The effect of First Amendment on free speech, the removal of right to property from Constitution, legislating outside of the criminal procedure code, where the protections given to us by the code on bails and other things are not there. The problems we have seen. These may be problematic. And socially speaking, I was very surprised to read the NCRB, National Crime Records Bureau report, the Crime Report 2022, that we have always thought Assam to be a progressive state with gender issues. But you'll be surprised that we have had more dowry deaths than Haryana. Our populations are similar, and West Bengal has the highest number of dowry deaths. So this was very surprising. We don't know the answer to it. I mean, we may not know the answer to it. But at least, again, arguably, we know the simple solutions, simple problems. Pendency, we all know Damini case, 1996, Tarikh pe Tarikh. Then Chief Justice Bobde, in 2016, he shed tears in front of the Prime Minister in Bigyan Bhavan. But since the last 30 years, pending cases from Damini's time, 1 crore to 3 crore. Division of this thing, crime protection and crime detection. Crime detection, at least, if not crime prevention, crime detection can be made autonomous. This demand has been made by the DGP's conference. So the Honorable Supreme Court has observed. Case Perot, CBI. So, union government has not done it. No dispensation has done it. No one who runs office, government does it. And in state, since law and order is a state subject, none of the parties do it. So, this is a big question. How do we survive as citizens? We don't have, my friend, say, I don't know if she has come here, she's coming. She organized a protest against this Calcutta case. And what is the answer? We have been organizing protests since 1990s or even before that. So today, we have this eminent panelist, academic and practitioner, both among the court and police. So the format will be, first hour, roughly 15 minutes, each of the panelists will speak. I request all of you, you have got a A4 size paper in your folder, and I think there is a pen also. You may write your questions, and this is going to be a very interactive session. After the first hour, we will take questions, and to our heart's content, we will be taking the questions. So I hand over the mic to Mr. Parikshith Kutur.
Firstly, I'm the youngest of the people in the podium sitting here. I would thank Pankaj sir, and I would seek blessings of all the people sitting on the podium before starting this. As all of us have come here to discuss about what are the judicial reforms, especially with regards to criminal justice system, which are required in this country to make sure that we as a country become a more acceptable society per se. As the brochure suggests, there are 2 aspects of criminal justice system. One is the police and the other is the courtroom systems. The crime per se starts. What are the obstacles for conducting efficient investigation system? The biggest issue which we face as a country is the police forces are understaffed. They are severely understaffed, and there's no clear distinction between law and order and investigation mechanism. For 144 police officers, the number of people they have to administer is 1 lakh, whereas the recommended ratio is 222. So they're severely hampered in terms of conducting investigation. And investigation is a very, very important element of criminal justice system. Unless the investigation is carried out in a proper manner, the result, the fruitful result of a criminal case will never come to light. So that is the first major issue which has to be addressed, for which we need political will. We need people to push the political masters to appoint more police officers to conduct effective investigation processes. The second is the judges. The police officers are forced to juggle between law and order and investigation, which is a very difficult task. If you look at the life of a police officer, on one day he'll be doing a protocol duty, sometimes on another day he'll be investigating some matter. So from looking at it from the police angle, it is a difficult task to conduct an investigation in a seamless manner. There are multiple number of Supreme Court guidelines with regarding to this, where they have said that state security commissions should be set up, fixed tenure for DGPs and senior officials should be fixed, separate law and order and investigation teams should be formed. This was at multiple number of times Supreme Court has been giving guidelines telling that you form a different wing for law and order, you form another wing for investigation, where investigation becomes seamless. Unless the investigation is seamless, the result of investigation will not become fruitful. The biggest difficulty is more or less investigations are lopsided. The next aspect is with regards to police reforms, creation of police complaint authority, which in Prakash Singh's case, Supreme Court has clearly told that form an authority where people, if you have grievances against the police officers, the grievances can be registered and the same can be acted upon. At the same time, improvement of how police department functions. Because the first point of contact with criminal justice system is police. Courts only come in at the second point. The first point is the police. Only when we address that aspect, the other things will get addressed at a later point in time. Second aspect is with regarding to workloads. According to Center for Study for Developing Societies, 2018 report, 30% of the cases filed in 2016 are still in pending investigation stage even as of today. So if you're investigating a matter for 4 years, 5 years, there might be some critical witnesses who have left the place, they're not available, they have expired, which becomes a very, very important aspect in the criminal justice system. Often what happens in courts is, looking at it from the prosecution side, there is a particular witness. That particular witness becomes a very critical part of the case. That witness goes either missing, or he is expired, or he is not available. They might have left the place. So you cannot prosecute in that manner. They lose the most important element of their case. The next aspect is with regarding to vacancies. Close to 30% of vacancies are yet to be filled in police department. So the 100% load is being held by 70% of people who put in at least 14 to 15 hours a day on a regular basis. That is very common in police department to put 15 hours. In fact, my sir will give clarity on that aspect as to how difficult is it to go through from their end. This is a very human problem. I mean, we complain about 9 to 5 jobs. To be on the field and doing 15-hour shifts, 16-hour shifts is not easy. That, in fact, also leads to the larger question of how should we look at police reforms? Because that is a very important aspect of criminal justice system. Unless we address this entire issue as a whole, overall criminal justice system cannot be reformed. Protections against custody. Each one of the aspects which are mentioned, I am trying to address them. While legal protections under 120 of the new BNS Act is there, but what happens during investigation is, instead of relying on evidence, unfortunately sometimes they force the person who is being interrogated to give a confession, which eventually does not get admitted in the court. So that is a major issue. Based on a particular statement made before a police officer by way of a certain force, due to the position which they are in, such statements, when they come to court, they don't stand the test of trial. It's a major issue which in most of the cases it happens. So that is an issue which has to be addressed, where abuses pertaining to custodial torture have to be addressed. Unless that is addressed, the overall justice system cannot improve. And one more aspect which has to be looked into with regarding to custodial torture is the day where we start looking at investigation as a scientific process rather than a process where we want to get it done. That is when the reform starts. Because investigation is a scientific process. There is a manner in which investigation has to be conducted. There are codified laws. We have to adhere to those codified laws. In fact, one of the issues which I feel most of the state police departments have is a lawyer not being part of their team while they're conducting an investigation process. That would make the process more seamless, where they will be able to collect cogent evidence, couple that with the circumstantial witnesses, which would ensure that they will file better charge sheets, which will help overall justice system. With reference to political interference, Supreme Court time and again has been coming down hard, telling that they should not interfere in in process of investigation. The moment political interference comes, the process of investigation goes for a toss. We like it, we don't like it. Executive in certain times will be compelled to investigate a matter in a particular manner based on their political whims and fancies of the government, whichever government is incumbent in that day. First, in fact, there are set guidelines which were set in D.K. Basu's case, where they said that police identification, they said 8 or 9 parameters. They said, first, police should identify the person and say, is this the right person who is the accused? The second, there should be a memo of arrest which has to be issued. That then they have to be informed, someone in the relatives have to be informed. Subsequent to that, notification, the accused who is there, their rights should be informed to them. Medical examination has to be conducted. Data entry of the accused has to be maintained. They would be provided with legal aid. And also magistrate should ask certain pertinent questions. So these are very important aspects which are to be incorporated. In a lot of cases, most of them are being incorporated, but there are some slip-ups here and there. With reference to political interference, the biggest issue which happens is that unfortunately or fortunately, politics and crime are always intertwined. So for reasons for their own benefit, politics get interfered with investigation. Unless there is an agency which is clearly demarcating investigation away from political interference, this cannot be addressed. And as long as there is political interference, especially in high-profile issues, investigation cannot be done in a very seamless manner without favor and fear. That is a major issue which this country has been facing from a long time. Unless we address that aspect, major issues with reference to high-profile cases cannot be addressed. Political interference can be at the highest level to the lowest level. From a sarpanch to a MRO, Mandal Revenue Officer, to at every stage there is political interference where they try to influence the investigating officer to carry out certain things in a certain manner. Unless there is an independent agency which is dealing with investigations, this issue cannot be addressed. Unless law and order and investigation are separated, political interference cannot be reduced. See, we can't come to as on today, we can't come to a situation where there will be no political interference, but we should take enough steps where we reduce the amount of interference which is happening. That is the best endeavor which we can put forward. One more major challenge which the department faces is the technical support of forensics and specialized knowledge. As we know, we are in a day and age where technology has advanced. There are new kind of crimes which are being committed. There are cyber offenses. In these scenarios, the biggest difficulty is we do not have enough forensic abilities with reference to investigating crimes. I'll give you a data. There are 7 labs for forensic science investigation in the country, central labs. 32 labs at the state level and 80 labs on regional level. For a country of 130 crore population, this is what we are looking at. And this will eventually come back to pendency of litigation. Assuming there is a scenario where whether a particular video is pirated, whether a particular video is correct or not has to be examined. The same is sent to a lab. The examination and the entire thing, the report coming from the lab will take at least 6 months to a year, where nothing will happen in that matter. For 1 year, nothing will move in that matter. So unless we set up more labs, unless we look towards going in a scientific approach to approach the investigative process, judicial reforms cannot happen. Even if they happen, it will only be for the sake of name, and nothing substantial can happen. There are 7 labs, central labs. One is in Hyderabad, Calcutta, Chandigarh, Guwahati, New Delhi, Bhopal, Pune. For a country which is so huge, this is a very shameful figure. It's really, really alarming that we don't want to empower the investigative process. Unless we empower this process, the result will not be right. We cannot expect results without getting the process right. Only when the process is right, the result will come. So unless we focus on those aspects, the results will not show up. Separation of crime prevention and crime detention. As my learned seniors have been addressing, Pankaj sir has addressed, the difficulty is in terms of crime detection and crime prevention. These are 2 different aspects. Crime prevention is on a much earlier stage. Crime prevention is a stage where education comes into being, family values comes into being, how we are moving as a society comes into picture, and what are the kind of steps which we are taking to ensure that crimes do not happen come into picture. Suppose, I'll give you an example of one small act, that is your Motor Vehicles Act, which is drunken driving. It was a menace in Hyderabad, say about 10 years ago. Firstly, the department approached the entire situation in a different manner. They said, okay, there is a menace, there is drunken driving, how do we address it? After drunken driving, there were accidents. That is nothing but a process of what is happening. So what they did is they split into 2 halves. One, they started educating people about not to drink and drive. That was the first drive, they did it massively. Subsequent to that, what they did is, they started putting various number of checkpoints, especially where they know for a fact that they will get hold of people. And they were doing this job very dispassionately, irrespective of social strata. The numbers have reduced, drastically reduced. Now people, drinking is not a crime, but driving a vehicle in an inebriated condition is a crime. Now what have they done? Now they've come out with a solution like, say, cars where driver comes, takes them home. It is safe. There is an employment opportunity which got created out of this scenario. Police actually started pushing them that if they are caught, there is no way that you're going to go out. You have to go, follow the due process, either pay a challan or whatever the judge says, 1 day, 2 days imprisonment. You have to face that, or social community service. It's a very small example, but these are 2 different facets. One facet is prevention. Prevention can happen through measures like education, sensitizing citizens, helping them understand that crime is it's not cool. The other aspect of it is enforcing law. So unless both of them happen hand in hand, we cannot look at results happening our way. Reasons for why there are 3 crore pending cases in Indian courts. One of the major issue why we have so many cases pending is, one, Indian courts have a lot of judicial vacancies. There are close to 4,000 positions which are pending in the trial courts. And with that kind of pendency, if you typically walk into any metropolitan magistrate court, you'll be looking at 150 to 200 cases which a metropolitan magistrate has to attend to on a daily basis. It is not humanly possible to attend to those kind of cases. So eventually what happens is you end up giving a date because that is the easiest thing to do. Only in few cases where there can be trial which can be conducted, it will be pushed on. But what is happening is there are not enough number of judicial appointments which are happening. Even if judicial number of appointments happen, suppose a judge comes, takes over a trial, there'll be 1 or 2 dates where he has to really understand what is happening. He cannot stay away, he's not a machine. He has to come, sit, observe, for which there is good 3-4 months which is gone. So these are major issues which Indian judicial system is facing, which have to be addressed. That is appointments, 1. 2, there are a lot of procedural issues such as service of summons. So typically what happens is, if a witness has to be present in a court, a summon has to be sent. So this process of sending summons itself sometimes takes about 2-3 years. I mean, just to send a summon and get a presence of a witness to be in the court sometimes takes 3 years. It's really unfortunate that we are in this situation, but these are things which can be addressed. There are some of the officers and some of the court officers who make it efficient by sending summons through WhatsApp. These are means in which you can kind of use technology to make it better and more seamless. Second, I also blame my own community of brethren, that is advocates, where we end up taking adjournments. I will not lie that we do it. But it also depends on the judge as to how they have to be stern with advocates when adjournments are being sought for. These are the aspects which we are facing as a overall system. I'll go to the last slide, which is the most important slide, and I'll close my presentation. Lopsided charge sheets. The difficulty which we face is because there's no adequate training, the charge sheet which are filed in the court, charge sheet, first there'll be an FIR. After FIR, investigation is conducted and then a charge sheet is filed. Charge sheet becomes the basis of your the entire investigation process, and that will lead to the prosecution. So in case of charge sheet, what happens is, because they are not adequately trained and they don't have enough tools, lopsided charge sheets are filed, due to which a person, even though who has committed a crime, has a possibility to escape it because charge sheet is not done properly. So this is one of the major issues which we face as an entire system, and unless we address this aspect of charge sheets being taken very seriously, this issue cannot be addressed. And one more aspect which is very important is rights of the accused versus rights of the victims. The entire balance of the criminal judicial system lies on balancing the rights of the accused versus rights of the victims. Because state or police becomes the party on behalf of victims, victims also suffer. They lose hope. So in order to address that, we have to maintain that fine line of balance between balancing the rights of the accused as well as rights of the victims. Thank you so much.
Thank you, Mr. Kutur. I hope you have had many thoughtful questions. I would encourage you to write it down, and we'll come back to his. So now I invite Shri Saikia sir, that if you can speak.
Respected Shri Angshuman Bora, Advocate, Guwahati High Court, Shri Parikshith Kutur, Advocate, High Court, Telengana, Dr. Sarfaraz Ahmed, Associate Professor, West Bengal National University of Judicial Science, Shri Pankaj Das, Moderator. I am very much happy to address you, address the elite group, and I am thankful to the organizer and to India Polity Institute for giving me an opportunity to speak this occasion. I'm a retired person from Assam Police. I retired as the Superintendent of Police. And my introduction is given by at the beginning of this program. I have gone through all the points here relating to police regarding obstacles in efficient investigation. As a police officer, I worked in throughout the state of Assam, and I interacted with many investigation officers. I lead them, I guided them, but I have observed that there is lack of experience, lack of knowledge on the part of investigating officers. There is no chain of evidences in the case diary. In most of the cases, there are very good officers, no doubt. So many good officers are there. So many knowledgeable officers are there. But most of the officers, nearly 60% officers, they don't have the idea how to write a case diary and present it before the court. There is no chain of evidence at all. There is no specialized training for investigating officers. Some of the officers, they are sent to the academy or other institutions for training, but it is very few, 2%, 3% officers, they got the proper training of investigation. Others officers, they don't have the opportunity to undergo any training regarding investigation of the case. Crime conference, monthly crime conference. There is a system of monthly crime conference in every district headquarters. The police invite judicial officers also, GOP leaders, district judge, additional district judge. All the officers attend. They suggest police. They show their loopholes. But only a few officers, they could attend this crime conference due to their excessive workload. There is lack of sufficient infrastructure. Infrastructure, I mean, that is computer, the other related record, case record, library. It is not available in every police station, so that police officer can take guide of. My practical experience is that the investigating officer, he remains busy for law and order duty or other duties, VIP duties, and at the end of investigation, he hands over the case diary to one retired person, retired inspector. And he writes the case diary on behalf of the police officer. In maximum case I have seen, one inspector, retired inspector is sitting at the police station, either at police station or at the residence of officer in charge or some investigating officer. He writes the case diary on behalf of the investigating officer. The person who writes the case diary is not well acquainted with the facts of the case. He had not visited the place of occurrence, not interrogated the accused person, not recorded statement of the witnesses, but he is writing the case diary. Therefore, it is seen that a huge percentage, I don't know the actual percentage, maximum percentage cases are failed in the court of law. A special training for all the investigation getting officer under the guidance of one experienced criminal lawyer, senior experienced police officer is necessary, so that IO can present the case in a proper form to bring the proper judicial system in operation. In most of the cases, what happens, IO prioritize the important cases, VIP cases. VIP cases in which there is political pressure or pressure from the senior officers. The other case remains neglected and it is pending for a long time. In most of the cases, only the important cases, only the VIP cases are prioritized. Another major reason, it is the most important reason, the workload of the IO. The same IO, he attends all the crime scene and he also attends in all the law and order situation and VIP duties. He summons some witnesses, summons some criminals for recording statements. Suddenly, he has to go for VIP duty. He has to go out for VIP duty. Therefore, proper investigation is not possible by IO unless investigation and law and order is completely separated. There should be a separate officers, investigating officers, and separate law and order officers. Nowadays, in every district, one additional SP crime is appointed. He looks after the case. Some reforms are there. Workload of some IO, it is distributed. Case diary of the this Guwahati IO, Dispur IO investigating officer. During my tenure, I have seen they have 500, 600 cases pending with one IO only. It is heavy. Now it is rationalized. It is distributed to other district officers who are sitting idle, who has no work. Investigating officers, sometimes they are disturbed. Proper investigation is not possible because there are some interference. I will not tell that all the politician interference. I should not blame it. Only the politicians. For vested interest, they get pressure from the several quarters, and therefore proper investigation of the case is not completed. In many cases, it is seen that some innocent persons are arrested and sent to jail. This is due to lack of a proper mechanism in the police department. There is no proper mechanism even in the police department, and IO is also not responsible for arresting a wrong person because he is discharging in his duty in his official capacity, and therefore he is exempted from any criminal proceedings. Next point is whether there should be protection, there is protection for against custodial torture or custodial interrogation. As all of you know, you are mostly dignified persons, you are advocate. Most of you are advocate, you are well dignified person. When police arrest a person, his interrogation in most of the cases, except some officers, there are 50% honest officer, 50% very dedicated officers, except some honest officers. His interrogation procedure depends on his social status or financial capacity, how he will be interrogated, except in some other very important cases. There is no doubt there is use of physical force also sometime, and it is necessary also. because it is seen that in many cases, in most of the cases, the accused confesses the matter before the police due to fear. But sometimes he discloses the factual statement, but later on he denies it before the court. Regarding political interference on police officers, I want to say that it depends on the officer whether he will take the political pressure or not. Political bosses, when we joined in the police service, during our passing out parade, we swear that we will follow only the lawful commands from the superior, not unlawful commands, only the lawful commands of the superior. Therefore, police officer is not bound to follow any unlawful command. If he expects some benefit in exchange of his unlawful acts, he can take benefit of, he can bow down before the political pressure. But if he thinks that I should not bow down to the political bosses and I should go by law, then nobody can do him anything. They can be transferred. One OC is sitting as OC, he will go to other place. Inspector, he will go work somewhere as an inspector. If SP, he goes by law, and if political bosses do not like his activities, then he will be transferred out to some other places, but his rank will remain the same. His remuneration and rank will be remain the same. It depends what type of police officer is when they they bow down before any pressure. In my practical experience, I'll say that when I was SP, Superintendent of Police, Vigilance and Anti-Corruption, I caused an inquiry against the procedural anomalies of APSC and illegal properties acquired by the chairman and other members of the Assam Public Service Commission. At present, Rakesh Pal is in jail. His later stage investigation was done by some other officers. But what is important, at that time when I started my inquiry, that time Rakesh Pal was close, he was very close to his political bosses, those who appointed him. To High Court, then probably Raghubir Singh or some other persons was there in the High Court as Chief Justice. I was then posted, I was in vigilance. When I started inquiry of Rakesh Pal APSC, I was transferred out to the 8th Assam Police Battalion, suddenly. That was not a bad posting. Suddenly, Akhil Gogoi submitted a petition that this Mukul Saikia, he submitted a report to the Honorable Court regarding anomalies of APSC and properties acquired by Rakesh Pal and other members. That no action was taken on the basis of the report submitted by the Mukul Saikia. So he should be reinstated to the Vigilance and Anti-Corruption Department, and investigation should be handed over to him. Probably I was the only first officer in the Assam Police who was transferred and posted by name. ঠিক আছে সকলোকে মই মোৰ ফালৰ পৰা আন্তৰিক ধন্যবাদ জনালো আপোনালোকে মোক ক'বলৈ সুযোগ দিয়াৰ কাৰণে জুডিচিয়েল সিস্টেমটো আপোনালোক সকলো এডভোকেট বহুত ইয়াৰ পৰা জুডিচিয়েৰীটো যাব আমি জেলত যেতিয়া ভিজিট কৰোঁ জেলত যেতিয়া যাওঁ মই যেতিয়া পুলিচ অফিচাৰ আছিলোঁ বিভিন্ন জেলত গৈছোঁ জেলৰ 90% যি আসামী আছে দুখীয়া মই তেতিয়া এটা মনত প্ৰশ্ন হয় যে দুখীয়া মানুহেহে ক্ৰাইম কৰে নেকি 90% মই আপোনালোকক এপিল জনাম যে যিমান পাৰে দুখীয়া মানুহক আপোনালোকে সহায় কৰক দুখীয়া মানুহক সহায় কৰক আপোনালোকে poor people pay but rich people pray আৰু poor people যি পেমেন্ট কৰিব rich people প্ৰেয়াৰতকে পইচাতকে বহুত বেছি আপোনালোকে পাব এদিন নহয় এদিন আৰু ইনভেষ্টিগেশ্যন আৰু যিটো ল এণ্ড অৰ্ডাৰ এইটো সেপাৰেট কৰা কথা মই প্ৰথম চাকৰি প্ৰথমৰ পৰাই শুনি আছোঁ যে ইনভেষ্টিগেশ্যন আৰু ল এণ্ড অৰ্ডাৰ সেপাৰেট হ'ব আমি ভয় খাওঁ যে ইনভেষ্টিগেশ্যনটো পেলাব নে ল এণ্ড অৰ্ডাৰ পেলাব আমাৰ পোষ্টিং তেনেকুৱা শুনি আহিছোঁ মোৰ চাকৰি শেষ হ'ল 29 ইয়াৰ্ছ ছাৰ্ভিচ কৰিলোঁ এইটো নহ'ল এইটো কেতিয়াও নহয় মই এটা সাধু কৈ আপোনালোকক সমাপ্ত কৰিম এজন মানুহ তেওঁ কি আছিলে আইচিউত আছিলে বিৰাট সিৰিয়াছ মানুহ তেওঁ আইচিউত আছিলে আইচিউত থকা অৱস্থাত মৰু অৱস্থাত তেওঁ ভগৱানক প্ৰাৰ্থনা কৰিলে যে ভগৱান মোক যেনে তেনে বচাই দিয়া মই বচাই দিলে মোৰ এই বিল্ডিং যে তিনতলা বিল্ডিংটো মই দান দি দিম কৰিব তেওঁ মিৰাকল বাচি গ'ল এতিয়া তেওঁটো ভগৱানক কথা দিলে যে মই বচাই দিবলৈ ক'লোঁ মইতো কিবা এটা দিব লাগিব তেওঁ এটা বুদ্ধি কৰিলে যে মই এইটো অকশ্যনত দি দিম অকশ্যন কৰিলে যে মই এটকাত মই বিল্ডিং বিক্ৰী কৰি দিম কিন্তু এটা কণ্ডিশ্যন আছে লগত মোৰ কুকুৰ এটা আছে তাৰ দাম 1 কোটি এটকাত বিল্ডিং বিক্ৰী কৰিম কিন্তু লগত যিটো কুকুৰ আছে তাৰ দাম 1 কোটি তাৰ বিল্ডিং বিক্ৰী হৈ গ'ল সি 1 কোটি পালে আৰু 1 টকাটো গৰীব মানুহক দান দি দিলে তাৰ কথাও ৰ'ল সকলো ৰ'ল গতিকে জুডিচিয়েল যিটো ইনভেষ্টিগেশ্যন আৰু ল এণ্ড অৰ্ডাৰ এইটো সেপাৰেট হোৱাটো সম্ভৱ নহয় খুব সম্পূৰ্ণ হোৱাটো সম্ভৱ নহয় কাৰণ যদি সেপাৰেট হয় ইনভেষ্টিগেশ্যন পাৰ্টটো জুডিচিয়েৰীৰ তত্ত্বাৱধানত আহিব জুডিচিয়েৰীৰ গাইডেন্সত আহিব যিটো কোনো পলিটিচিয়ানে নিবিচাৰে সেইকাৰণে সম্ভৱ নহয় শেষত এই অনুষ্ঠানক মই পুনৰ কৃতজ্ঞতা জনাই মই মোৰ বক্তব্য সামৰণি মাৰিলোঁ
Thank you so much. I think we have got enough points for taking the discussion further. Now I request Professor Khan to speak. You may use anything.
Good evening, everyone. I'm indeed grateful to India Policy Institute and Pankaj sir for inviting me for today's program. All the dignitaries on dais, the members who are present here. So due to paucity of time, let me go to the point which we want to discuss in 15 minutes time. There are many things which we can discuss on criminal justice reform, but one thing which we must keep in mind, the timing when we are discussing it. In India, as claimed that the biggest criminal justice reform brought from the 1st of July, right or wrong, we can judge it, but there are 3 laws which has come into force from 1st of July. And then we have to see that whether really we miss some opportunity or we really achieve something out of those 3 legislations from the challenges which are there in front of us. There are many committees report, as in the beginning Pakaji was saying about Malimat Committee. 2003, the Malimat Committee has given a very detailed report on criminal justice reform. Then we have on police reform, there are a few committees reports, Solicitor Lavji reports. Then there's another committee on criminal justice policy by N.R. Madhava Menon. That committee also given a detailed report. There are many Supreme Court judgment, as discussed the Prakash Singh judgment earlier by brother, on the criminal justice reform or the police reform, etc. Now, a few things which I want to say. The first is Malimat Committee in 2003, when they look at the criminal justice systems of India, what they suggested is that we follow adversarial system And they discuss in detail what does adversarial means, what does inquisitorial means. And what their suggestion was that there are some gaps or some gaps exist in the adversarial systems, because in adversarial system, judge rarely participate. So the amount of involvement of the judges we see in inquisitorial systems in Germany, in civil law countries, we don't see the judges' participations in Indian system. And its adverse impacts are when a witness turn hostile, rarely judges are there who take some initiative or start proceedings against the persons who become hostile. One of my research scholar recently submitted his thesis on hostile witnesses. And we found that in West Bengal, his study was on West Bengal, that not even a fraction number of cases or occasions when a witness turn hostile, judges intervene or actively do something that point of time. Because we have a law prescribes something for even prosecution in some circumstances when someone make false statement. Now, these things can be, gap can be filled up if we have something in between both of them. So, adversarial, inquisitorial, and that the system which followed many part of the world or maybe international tribunals, particularly ICC, etc., which called accusatorial system, which is the mixture of both adversarial and inquisitorial, where judges can also participate. Now, we have some of the provisions in the CRPC we had earlier, evidence law also have. We have some, those provisions remain there in BNSS, like under the CRPC 311, which the number has changed now to 323 or 324, or Indian Evidence Act 165 was there, which become 168 in the new law. So those provisions are there, but we need to see that in practice, really judge, not only judge as an umpire, but they have to take part in the processes when there is a gaps. For example, brother, when he was saying about the summon procedure. Now, ultimate controller is the judges. Judge has to act. Lawyers can file application for adjournment, but the deciding authority lies with the judge. So the day judge start that they have to decide, and the ultimate objectives for be to quest for justice. That's what Manimat Committee has said. So with that thing in mind, the day judges started working, might be the situations may improve. Another thing which I want to say, because we got 3 law, one of the right which we consistently has seen and argued about is right to speedy trial. Many of the menace which we see, the number of conviction is less, etc. This can be resolved. The number will automatically increase if the speedy trial can be ensured, if it can fulfill. Because the chances when the trial is delayed, the witness will turn hostile. There are many things are there. Many times witnesses are manipulated, victims are manipulated, etc. All those things happen in the processes. So if we have a speedy trial, the things may change. In the new law BNSS, we see some improvement. We can't say there's nothing in the new law. So in the new law, you will say in BNSS, it says charge can be framed within 60 days. After argument, within 45 days, the judgment can be given. Discharge application within 60 days. So in that way, sporadic, you will find many places, some timelines are given in the BNSS new law. But was that going to serve the purpose? Now, if the right to speedy trial is a fundamental right under Article 21, which Supreme Court has consistently has talked about, then time has come when we can think about at least some outer limit within which we can decide the case. We cannot wait for 10 years, 12 years, 15 years to complete the case. If you remember, there was a Supreme Court judgment in 1999. It's called Raju Sharma. In Raju Sharma, one Supreme Court fixed the time limit that the trial should be completed within 3 years' time. If it's not complete, next date will go to next step. Again, the appeal was filed in Raju Sharma 2. In Raju Sharma 2, Supreme Court clarifies that the delay is caused by the accused. That period need to expunge, and then you 3 years period you determine. But that judgment of 1999 and the second 2000 was set aside by the Supreme Court in P. Ramachandra Rao in 2009. On technical ground, what was the ground was that P. Ramachandra Rao Supreme Court says that earlier A.R. Antule, common cause 1, common cause 2, all are 5 judges bench, common cause 1, R. Antule, 5 judges bench decision. There the issues come with the right to speedy trial is a fundamental right. Answer was yes. Can we fix the time limit? Answer was no in those cases. Raju Sharma was further progress on it. That okay, if you have a right to speedy trial, some meaning, then you fix the time limit. But Supreme Court said that look, how can if a 5 judges bench has not fixed the time limit, how the lower bench dare to fix the time limit? So on technical ground, P. Ramachandra Rao set aside Rajiv Sharma case. Now, when we are getting new law, BNSS we are getting, we are challenging, or we are at least arguing that we have a recognized right to speedy trial, because we have many times we have fixed the time limit. But the government could have fixed at least one outer limit within which the trial can be completed. At least within this period, at least the evidence recording should be completed, or something which can specify. But in my view, we have failed there. Whether we can fix the time limit, but that limit somehow is not we able to achieve in those circumstances. Victim participation, there are improvement, undoubtedly. There are many things which the law has said. So victim can get the informations about the progress of the cases within 90 days. So 193 BNSS talk about it, which was not there earlier. But that's not enough. You require victim rights to participate as one of the stakeholders from beginning till end. Now, still BNSS has not seen a victim as one of the important stakeholder, and their roles are limited. So, victim participation, I think we need to look at that what kinds of policies should be there in future by which we can see the victim can participate in the processes. One of the rights which we have not talked about, our law has not recognized effectively, which we say right to reparation. Now, many times, our criminal justice system process itself become punishment, whether it's a false prosecution, whether it's for other reasons, for political reasons or otherwise. We know how the system works. Now, in those circumstances, if a person is got acquitted or he suffered imprisonment without any trial for longer period of time, are our law look at them? Are our law provide them repair whatever the harm the law has caused, because the legal process which cause harm to them. So can we have a system where which we can provide repair this harm by providing reparations to the victims? Even our system has not able to do that. Another thing, we always talk about convictions. Now, in my view, we do require convictions. We look at many times severity of punishment. So when we have a West Bengal this incident happened, unfortunate incident in the hospital, government found as a means to resolve is that immediately they make an amendment bill that make death penalty. Now, I personally believe that what India require is not the severity of punishment, but surety of punishment. Even if persons get a lesser punishment, they must get surely punishment. So can we improve our system where we'll see that those who are perpetrators are surely get punishment, whether less or more? Because the time when you say only talking about the severity, we can do death penalty, neither life will happen nor death will happen. And we know our system, how the system is being failing continuously. Malimat committee, that point of time talk about your use of more restorative justice or maybe alternative dispute resolution system. There could be some mechanisms which can be used in criminal cases. Now our law has, even in the new law, they have failed to acknowledge it or failed to increase it. So when we see the compounding of offences, provisions, etc., we don't see much significant changes from the earlier law. In fact, most of the provisions are same what was there from the earlier law, and we have to see how we can improve upon those systems. My brother has talked about both on the judges' point and the police. I will not touch upon it. When we talk about the functionaries, now the first tier function is definitely police. Then you have a very important function is prosecutor. We seldom talk about them. Then you have a judges. I personally feel that among all these functionaries, the least accountability mechanisms, if available, is the for prosecuting agency. We don't have any kinds of mechanisms to create some accountability system for the prosecutors, or at least to have some kinds of mechanisms where there is acquittal, why acquittal, who will check it. Now, one of the reform on that direction was, and it was also suggested by Malimat Committee in 2003, but it was incorporated much later in the CRPC section 25A, where they talk about Directorate of Public Prosecution. Now, there is some significant development happening in the new law in that regard on the prosecuting agencies. So when they have a Directorate of Public Prosecutions in the old law, section 25A, The word was in the beginning may. Impliedly, there is a discretion on the part of the government to whether to establish it or not establish it. Many places in the country, they have not established it. In some places, they established as a pilot project in few districts only, and thereafter it has not expanded to other districts. Now, under the new law, there is a further improvement, and the new law says in section 20, I think, on the prosecuting things, they're talking about district directorate of prosecution. So every district will have a directorate of prosecutions. One of the significant things which they suggested is in the new law that the qualifications for the persons who will hold that district director of prosecutions or deputy director or assistant director, either lawyer or prosecutors or persons from the judiciary. So session judge for the director, deputy director, and the judicial magistrate for the assistant director. Impliedly, indication is that might be the judicial officers will be deputed to work as in director of prosecution or deputy director or assistant director. That might be the intention. That's why section 20 of new law is talking about it. But then, again in the new law, in the beginning say state may. The time we give discretion, the state is not going to implement in most circumstances because the political power always wanted to have some kinds of a control on the prosecuting agencies. Why I'm saying is because even if you see the old law, and the same thing in old law, section 24, clause 6 said, when there's cadre of prosecutor, public prosecutor shall be appointed from there. But we see almost every state throughout the country make amendment in clause 6. And what were the amendment earlier by the state, in the new law, that thing has been incorporated. So if the state thinks that there is no competent persons in those cadre of prosecutor, public prosecutor can be appointed from the panel of the which prepared by the district magistrate in consultation with of the session judge or district judge, etc. Now, in those circumstances, again, there is whether really we are going to improve that system, I doubt. So there was an opportunity under the new law that they could have make it mandatory. If you have to really think about improve criminal justice systems, this is one limb. Without one leg of the prosecuting system, we cannot improve our criminal justice systems. Police need reform, prosecutor need reform, judicial system need reform, other functions need reforms. We require a system under which all these functionaries will able to provide those kinds of mechanisms, then only we able to improve upon our system. One thing which I want to say here, to take this opportunity, we all know access to justice, again fundamental rights, we should get access to justice. There are many good things in the new law. When the new law has brought in, there are many good provisions. One of the excellent good provisions which I can think about, when police do search and seizure, now the new law talking about in 105, there should be videography, etc. Summon, warrant, all this trial process can be conducted by audio, video, electronic, means excellent provision. There are many good things. What I think which really will adverse it will have an adverse impact on the large number of the peoples from the remote areas, from villages, in accessing justice. And why I'm saying, I just by saying this point, I'll finish my comment. In accessing justice, earlier procedure, there are 3 ways in which a criminal case can start. So that's the criminal justice beginning or processes. So first is FIR. Second process was earlier 156 clause 3. That means you can go to the court, ask the court to direct the police to register FIR. Third was a complaint. Somehow in the new law in BNS says, in all 3 places, these are obstructions created. And what kind of obstructions? In the FIR provisions, where it was a consistently all along FIR says police shall register FIR. When someone's give information about commission of a cognizable offense, police has no other option. Police has to register FIR. Shall word is there. Supreme Court in consistently cases says that police cannot refuse registering FIR on the ground of jurisdictions or otherwise. Lalita Kumari judgment where they says that no refusal of the registration FIR, only margin available if the police has a doubt whether cognizable case is made out or not. If there's a doubt, they can do preliminary inquiry and then they will register FIR. Under the new law, it says In cases where punishment is up to 7 years, instead of registering FIR, police with their permission of their superior, their DSP, they can do preliminary inquiry to find out whether there is a prima facie case or not. Remember, the prima facie case, the duty to find out is not vested with the police. It is the duty of the court. Earlier, when we use the word prima facie case, we use in the context of when court frame the charge on prima facie case, when court take cognizance on prima facie case. New law expects that if there is no prima facie case, police should not register FIR. So to find out whether this is a prima facie case or not, the villagers will suffer, because when they go to the police, earlier when there is a mandatory, many occasions when this allegation raises that police do not register FIR. In fact, Malimat committee was so annoyed on this principle that many occasions police do not register FIR, that Malimat committee in its report says that we should remove this concept of cognizable thing. So Malimat committee in its report says, make every offense cognizable so that police cannot refuse to register FIR, and make offense arrestable and non-arrestable. That was the idea of Malimat committee. The background was that many occasions police do not register FIR. The same police who many occasions refuse to register FIR, new law says they can do preliminary inquiry. I think it will adversely impact particularly poor people, villagers who cannot have a say to force the police to register FIR. They will face challenge. Second, 156 clause 3. So police not registered FIR, a person can go to the court, ask the court to direct the police to register FIR. Now the similar provision which become 156 become 175. 175 clause 3. 175 clause 3 says that before registering FIR, directing the police to register FIR, magistrate must hear that police officer, why he has not registered FIR. Now, if nothing happened, it will delay the process. As soon as you ask for call for report from the police, it may take few days time. It will again adversely impact the access to justice. On complaint procedure, 200 CRPC it was earlier, now become 223. 223 says, before taking cognizance, magistrate must hear the accused. Now, trial has not started, case has not started. So, in all three entry points, the criminal justice system's entry points are these three. FIR, 156 clause 3, 200. In all three entry points, 173, 175 and 223, they have created a procedural hurdles which will create a difficulty in accessing justice to the victim. So this will definitely is going to create challenge. New law has come. I'll just say one minute to finish because the issue arises about the custodial death. Supreme Court in Shakila Abdul Ghaffar Khan directed that in the evidence law, you must add something. It's not direction. They recommended. Why they recommended is, there was earlier one Law Commission's report, 113 Law Commission's report, where Law Commission suggested that when death occurred in the custody, the colleague will not come and give evidence against the other police officer. So you must have a presumption clause that if death occurred within that particular circumstances, court can draw inferences that police has done something wrong. And if something otherwise, let the burden shift on them. So it was a 113 Law Commission's report. Shakila Abdul Ghaffar Khan case, Supreme Court recommended to the government that already 113 Law Commission's report is there, you try to implement it. Now, if the legislature wanted to improve upon the evidence law, they could have incorporated in the Bharatiya Sakshi Adhiniyam. There are many similar circumstances which we don't see incorporated in the new law. So these are the few things which I wanted to discuss with you. We will have a time definitely on questions answer where we can see how we can improve our criminal justice system. Thank you.
Thank you, Professor Khan. Again, I'll request everyone to write their questions if they have any. Now I request Shri Angshuman Bora to deliver his opening comments.
Good evening, everybody. A warm welcome to all of you. I welcome all the dignitaries here in the dais also. I'm here not to understand what is the law, what is the reform. Rather, I would like to share my experiences during my small tenure of this practicing as a lawyer. So, rather than discussing the integrities and the interpretation, and the reforms, I would like to share whatever the points as incorporated for today's discussion. I'll to share my experience in every point here so that it will be easier for you to understand, because I think apart from the lawyer here, the other people, non-lawyers are also present. And that is more important that they should also understand what is the reform all about. So apart from the English language, I would like to also address in Assamese so that we can understand in Assamia Matribhasha. Kobole beshi khubidha pam moi, bujibole hoyto khubidha hobo beshi. So first of all, the reforming India's criminal justice system. So already we have the 3 new acts, which is the earlier, the Konasil IPC. Now it is no longer the IPC exists. Now BNS, Bharatiya Nyay, IPC meaning to ki asile? Bharatiya Dandavidhi. Danda means punishment. That means no longer ETR punishment or kotha nai. Only Nyay. No longer there is a punishment. So that's the biggest challenge, biggest change they have brought in. Very surprising. Agor Dandavidhi ki enekwa aparadh ba danda korle je tak change korbo laga hol. Etu bor asorit kotha noy ne? Je dandavidhi eta enekwa danda korile jak sei dandor karone tak punishment di pelai, now we have brought in the new changes. That's why the dandavidhi has been changed and the BNS has come into the force. And the yate mok koise je there's a kabar ka hoise moru ka hoise. So ka hua karone moi immediately moi bhabisu after the show ei program pisot ka tu bor thurthura ase gorom pani dia nai eloke te gorom pani nidia karone moi immediately I think after the show I have to rush to the ENT doctor. I'll not go to a normal MBBS doctor. Because ki karone na jao? Because I need specialization for my small problem of throat I am suffering from. Kintu aji jodi mur ghorat sur ba dokaiti hoy, mur ghorat prothom kunjon doctor ahibo jane, ejon police ahibo who has no knowledge about the law to have a treatment. Mur ghorat jitu treatment is required in my house to find out who is the thief. Kun ahibo moi bisarilo ejon constable but a superior SI. Takokol, he has only the training, but they have no knowledge, the formal education of the law. And we are dependent on him. Kinu mur khoru eta ka holeu ba khoru sokur kiba ta aji pani ulai, I'll go to directly to an eye specialist, not to an MBBS doctor. Whereas eta murder criminal jodi hoy, tat punhore kune investigate kore? A person who doesn't have a formal legal education, and that is the biggest problem here. Kune investigate kori ase? Who's investigating? Do you have any law degree to investigate it? No, I have a vast experience. Muk training diya hoise Sohima, muk training diya hoise Hyderabad, muk training diya hoise. Is the training is sufficient? Whether you can interpret the law, which is the requirement of the law, that these witnesses are more important as those. Who will decide? And he will decide without having a knowledge, legal, formal knowledge, he will decide how to investigate. And the fate of the people, you can understand very well. So, moi khodai kaun, mo kunbai koi je, you are very expert in the criminal law. Tumi khodai case jika. Mo koisu mun nijor ekku brilliance yat nai. Because of the insufficiency, or because of the system of jitu lekuna ase, body moi he system or to he moi yat faida uthai pelai moi poisa earn kori aso. It's nothing more than that. Frankly speaking. Teloke koise je yate eta dise the workload, police officer workload bahut beshi. Workload at kyo naturally workload to telokar ase. Naturally, they don't have the expertise, যেতিয়া নাথাকিব ৱৰ্কলোড বাঢ়িব কামটো কৰিব যেতিয়া নাজানে এণ্ড অলৰেডি মোৰ ফেলো কলিগ তেওঁক অলৰেডি কৈ গৈছে যে পুলিচ অফিচাৰে কি ধৰণে হাউ দে ইনভেষ্টিগেটেড চামটাইমছ তেওঁলোকে যিবিলাক ষ্টেটমেণ্ট লিখিব লাগে তেওঁ কৈয়ে গৈছে মই যিটো কম বুলি ভাবিছিলোঁ তেওঁ অলৰেডি কৈছে যে এইটো আচৰিত কথা কেছ ডায়েৰী মানে কথাটো আপোনালোকে জনা উচিত হোৱাট ইজ দি কেছ ডায়েৰী এখন যেতিয়া ইনভেষ্টিগেট কৰে ডে টু ডে তেওঁলোকে লিখি যাব লাগে লাইন বাই লাইন যে ক'ত প্ৰচিড কৰিছে দি মোমেণ্ট হি টেক্স আপ দি ইনভেষ্টিগেশ্যন অৰ্থাৎ প্ৰচিড টু দি প্লেচ অফ অকাৰেঞ্চ ঘটনা যেতিয়া হৈ আৰম্ভ হ'ল তাৰ পৰাই তেওঁ এখন কেছ ডায়েৰী অৰ্থাৎ ডায়েৰী এখন মেইনটেইন কৰিব লাগে তাতে ডে টু ডে কি ক'ত গৈছে তাৰ পৰা আৰম্ভ কৰি ডিটেইলছ লিখিব লাগে কেছ ডায়েৰীখনত এভৰি পইণ্ট ক'ত গৈছে উইথ দি পেজিনেশ্যন উইথ দি টাইম প্ৰিচাইছলি এটা পিনে টাইম থাকে এটা পিনে পেজিনেশ্যন থাকিব দিজ আৰ ভেৰি ইম্পৰ্টেণ্ট এছপেক্ট অফ মেইনটেইনিং দি কেছ ডায়েৰী ডিউৰিং এন ইনভেষ্টিগেশ্যন এণ্ড কেছ ডায়েৰী ইজ দি বেচিছ অফ এন প্ৰাইমেৰী ইনভেষ্টিগেশ্যন চ' এই কেছ ডায়েৰীখন তেওঁলোকে এটা দুটা উইটনেছ লিখাৰ পিছত এজ হি যে ৱৰ্কলোড থাকে দেখিছে আৰু 10টা উইটনেছ আছে সেই 10টা উইটনেছক আৰু এক্সামিন নকৰি পেলাই প্ৰথম 2-3টাই যিখিনি কথা কৈছে একেখিনি কথাকে ডিটো তাতে লিখি পেলাই থৈ গ'লে ষ্টেটমেণ্ট অফ দি উইটনেছেছ বুলি লিখি থৈ যায় অৰ্থাৎ তেওঁলোকে প্লেচো ভিজিট নকৰে হয়তো যিকেইটা উইটনেছেছ আছে তেওঁলোককো এক্সামিন নকৰে বাট তেওঁলোকে ডিটো ফটোকপি অৰ দি ৰেপ্লিকা অফ দি আৰ্লিয়াৰ ষ্টেটমেণ্ট অফ দি আদাৰ উইটনেছেছ দেন মেক এনচিয়ৰ ইট দেট দি ইটছ ৰেপ্লিকা অফ দি আদাৰ চ' একেধৰণে তেওঁলোকে থেংক ইউ কেতিয়াবা কিছুমান কথা কাম দিয়ে কিন্তু Now, the police investigator, he proceeds to the places, apart from 2 or 3 interrogation statement, most of the statements, he comes back to the police station, and during his off period, or the belek duty na thake, minister, tetia he eke dhoroner statement lekhi pelai case diary thoi die, and that's become the statement, aru hei bilak statement pisot courtole ahe as a preliminary statement. Hey statement bilak pisot ami use kora hoy court use kore prosecution use kore aru defense use kore for the contradiction kintu contradiction koribo loga nohoy ei karone je witness bilake jetia ahi ulai prothom duta witness hoyto college yes egita statement moi disu third tour pra kobo je na ei bilak statement moi diai nai etu mur nohoy. So as a defense lawyer, I don't have to cross-examine those witnesses because the moment they will say that these are not my witnesses, I have been never interrogated by the police during the investigation, what is my requirement to cross-examine those witnesses? So a process to ki hoy, then the public prosecutor, then the only option remains for the public prosecutor to declare them as hostile. Hostile boli oboshe kono kotha in evidence act ot nai, ami etu use koru for the purpose of our nijor দৰকাৰৰ কাৰণে ইউজ কৰোঁ অৰ্থাৎ তেওঁক আকৌ হষ্টাইল মানে হ'ল কি প্ৰচিকিউশ্যনে নিজৰ উইটনেছক আকৌ জেৰা কৰিব পাৰে আদাৰৱাইজ প্ৰচিকিউশ্যনে নিজৰ উইটনেছক জেৰা কৰিব নোৱাৰে প্ৰচিকিউশ্যনে সদায় সুধিহে যাব লাগিব তেওঁৰ মুখত প্ৰশ্নটো দি পেলাই দিব নোৱাৰে সেইটো ডেটছ দি প্ৰচিডিঅ'ৰ এইটো ইমান আপোনালোকে জনাৰ দৰকাৰ নাই কিন্তু মই বেছিক কথাটো কৈছোঁ কিন্তু তেতিয়া সেই উইটনেছক নিজে জেৰা কৰিব লগা হয় যেতিয়া নিজৰ উইটনেছক নিজে জেৰা কৰিব লগা হয় ডেট মিনছ সেই উইটনেছজনৰ ক্ৰেডিবিলিটিটো তো কোৰ্টৰ আগত কমি যায় চ' সেইকাৰণে তেনেকুৱা উইটনেছৰ ক্ৰেডিবিলিটিটো নাথাকে চ' তেনেকুৱা সেইকাৰণে হষ্টাইল হোৱাটো তেওঁলোকৰ কাৰণে বিপদজনক কিন্তু উপায় নাই কিন্তু কৰিবই লগা হৈছে আহি পেলাই তেওঁলোকে লগে লগে ক'ব যে নহয় এইটো মই এইটো ষ্টেটমেণ্ট দিয়া নাই 161ত আৰু 161ত পুলিচৰ আগত দি ষ্টেটমেণ্ট যদি দিয়াই নাই কোৰ্টেও একো কৰিব নোৱাৰে আনলেছ ইট ইজ ৰেকৰ্ডেড আণ্ডাৰ ওথ ইন এন আনাডাৰ মেজিষ্ট্ৰেট বিফৰ দি মেজিষ্ট্ৰেটৰ আগত যদি সেই ষ্টেটমেণ্টটো ৰেকৰ্ড কৰে তাৰপিছত সি যদি সলায় তেতিয়া হি ইজ এন পাৰজুৰিৰ কাৰণে কোৰ্টত হি মে বি এ পানিছেবল আণ্ডাৰ দি পাৰজুৰি কিন্তু যদি নকৰে কি কৰিব হাৰ্ডলি কিছু মেজিষ্ট্ৰেটৰ তাত উইটনেছক লোৱা হয় এটা দুটা কেতিয়াবা লোৱা হয় কিছুমান কেছত মেণ্ডেটৰী এতিয়া অফেন্সেছ দি ছেক্সুৱেল অফেন্সৰ ক্ষেত্ৰত মেণ্ডেটৰী এপাৰ্ট ফ্ৰম বাকীবিলাকততো মেণ্ডেটৰী নহয় চ' সেইটো মেণ্ডেটৰী কৰিব গ'লে কি প্ৰব্লেমটো আছে ডেটছ দি ইম্পৰ্টেণ্ট ইছ্যু নাও আপোনালোকে সুধিব পাৰে মোক যে ৱাই নট দেন দি সকলো উইটনেছকে মেজিষ্ট্ৰেটৰ তাত লৈ যায় এইটো সকলোৰে তেওঁলোকৰ ষ্টেটমেণ্টবোৰ ৰেকৰ্ড কৰা হওক চ' ডেট they cannot be turned hostile during the proceedings, but it will take a hell of a time if every witnesses aru apnaloke asorit hobo ya logote di ami koi asu di speedy trial and if sobotke biggest যিটোক আমি সকলোতকৈ ডাঙৰ সংস্থাক বুলি কওঁ ইনভেষ্টিগেশ্যনৰ CBI কি কৰে জানেনে এটা সাক্ষ্য এটা কিবা এটা প্ৰমাণ কৰিবৰ কাৰণে তেওঁলোকৰ উইটনেছ আপুনি দেখা পাব 200 উইটনেছেছ ইন দি চাৰ্জশ্বীট 150 পৰা 200 300 উইটনেছ থাকে তেওঁলোকৰ চাৰ্জশ্বীট এণ্ড দে উইল নট এক্সকিউজ এনিৱান তেওঁলোকে সকলোকে লৈ আনিব এটা সৰু কথা এটা ছেইম কথাটোকে ৰিপিটেডলি সব উইটনেছৰ দ্বাৰা কোৱাব হুইচ ইজ নট নেচেচাৰী আদাৰৱাইজ কোৰ্টৰ কাৰণে ইজ দি কোৱালিটি অফ দি এভিডেন্স ইজ ৰিকুৱাৰ্ড নট দি কোৱান্টিটি বাট they will not follow that. Neither the court will follow that. Court will remain spectator. Anok CBI ani ase der pisot days etar pisot eta eketa kotha one particular document hoy to one exhibit ekhon koribor karone courtot then 10 people has examined for the one particular document. Ekhone document 10 ta manu exhibit korise. What is the necessity? Court bilak slide and spectator. Teloke kono proactive loan nolo etu khetrot so সেইকাৰণে ডিলে হ'বই ডিলে ইজ মাষ্ট এইটো উকিলৰ ডিলে কাৰণে নহয় আৰে উই আৰ ভেৰি হেপী এবাউট ইট নেচাৰেলি আমি 10টা উইকনেছ আনি আছে প্ৰচিকিউশ্যনে আনক 100টা আনক 200টা আনক তেনেকুৱাকৈ চলি থাকে চ' ডিজ আৰ দি এইবোৰ কথা আচল কথা এইবোৰ কথাত এই ৰিফৰ্ম যে আনিলে এই ৰিফৰ্মবোৰত এইবোৰ কথা কিন্তু ক'তো নাই ৰিফৰ্ম ক'ত আনিলে আপোনালোকে আচৰিত হ'ব নাও আই উইল টেল ইউ দি ষ্টৰি অফ এ ৰিফৰ্ম ইয়াত কৈ আছে যে পলিটিকেল ইনফ্লুৱেঞ্চ আছে নেকি দ্যাটছ ওৱান অফ দি এজেণ্ডা ইয়াতে দিয়া হৈছে হোৱাট ইজ দি পলিটিকেল ইনফ্লুৱেঞ্চ ক'ৰ পৰা ষ্টাৰ্ট হয় জানে when there is an appointment of a particular police officer big bosses in a particular area there from it starts যে মই যদি MLA হওঁ মোক সেই অফিচাৰজন ইয়াত লাগিব I will make a request to the superior bosses that this particular officer is required in my place and I will ensure to happen it এইটো হয় নে নহয় আপোনালোকে জানে নিশ্চয় এইটো হৈ আছে চ' বিকজ ইটছ ফৰ মোৰ যাতে কামবোৰ সকলমে হয় মোৰ কামবোৰ মোৰ প্ৰটেকশ্যন এইবোৰৰ কথা ভাবি মই তেনেকুৱা এজন মানুহ আনি পেলাই মোৰ এৰিয়াত মই বিচাৰিম দিট ইজ দি ফাৰ্ষ্ট পইণ্ট অফ পলিটিকেল ইনফ্লুৱেঞ্চ আৰু যদি পলিটিকেল ইনফ্লুৱেঞ্চৰ কথা কয় দিছ ইজ এ মোৰ প্ৰিজাম্পশ্যন হে দেই আই এম নট চিয়'ৰ এবাউট ইট কিন্তু মই আপোনালোকৰ আগত দাঙি ধৰিব খুজিছোঁ হোৱাট ইজ মাই প্ৰিজাম্পশ্যন আগতে এনেকুৱা এটা প্ৰভিজন আছিলে এতিয়াও আছে প্ৰভিজনটো ইয়াকে কোৱা হ'ল প্ৰি এৰেষ্ট বেইল বা এণ্টিচিপেটৰী বেইল অৰ্থাৎ আপোনাৰ যদি কোনোবা এটা আপোনাৰ এগেইনষ্টত এলিগেশ্যন আহে আপোনাৰ এগেইনষ্টত FIR হ'ব পাৰে ফৰ্মেল কিবা এলিগেশ্যন আহিব পাৰে তেতিয়া আপুনি যদি ভাবে ইফ ইউ ফিল that I should take a bail eta moi lobo lage before my arrest you can approach the sessions court or the high court for an anticipatory bail or a pre-arrest bail me anticipatory bail boli apni dhori lo so a pre-arrest bail kono karone ami jao eta reform to ki sanghatik reform yat anise apnaloke asoit hobo agote yate asil jeti anticipatory bailor karone jabo lage ejon manu তেতিয়াহ'লে তাতে লিখিব লাগে হোৱাট ইজ ইয়'ৰ ক্ৰিমিনেল এণ্টিচিডেণ্টছ অৰ্থাৎ পূৰ্বতে আপুনি কিবা অফেন্সৰ লগত জড়িত আছিল নেকি এণ্ড দেট ইজ ভেৰি ইম্পৰ্টেণ্ট ফৰ দি কোৰ্ট টু ডিচাইড বিফ'ৰ গ্ৰাণ্টিং দি এণ্টিচিপেটৰী বেইল টু এ পাৰ্চন হিজ প্ৰিভিয়াছ এণ্টিচিডেণ্টছ বুলি কোৱা হয় CRPCত সেইটো আছিলে আগৰ CRPCখন এতিয়া যিখন নাইকিয়া হ'ল এইবাৰ যিখন BNSS আনিলে ইমান ডাঙৰ ৰিফৰ্ম এটা আনিলে যে এণ্টিচিডেণ্টছ নালাগে It is not a mandatory now. এই এণ্টিচিডেণ্টছটো কিয় নালাগা হ'ল এতিয়া কোনে ৰিফৰ্ম আনিলে কি কাৰণে আনা হ'ল অলপ চিন্তা কৰকচোন কিয় এণ্টিচিডেণ্টছ এই যে আনিলে বিলখনত এই নতুন এক্টখনত এণ্টিচিডেণ্টছ নলয় কোনে আনিছে বিকজ যেতিয়া এণ্টিচিপেটৰী বিল বিচৰা হয় এই পলিটিকেল যিবিলাক বছেছ আছে তেওঁলোকে ক্ৰিমিনেল এণ্টিচিডেণ্টছৰ কথা তেওঁলোকে লিখিব নোৱাৰে কিয় তেওঁলোকৰ ক্ৰিমিনেল এণ্টিচিডেণ্ট এসোপা ভৰি থাকে গতিকে তেওঁলোকে দেখিলে ইট ইজ মাই ইণ্টাৰপ্ৰিটেশ্যন যে এইটো উঠাই দিয়া ভাল এইটো কিয় লাগে ক্ৰিমিনেল এণ্টিচিডেণ্টছটো এনেও এণ্টিচিপেটৰী বেইল দিবলৈ গতিকে এইটো উঠাই দিয়ক একেবাৰে উঠাই দি মুদাটো মাৰক এতিয়া ক্ৰিমিনেল এণ্টিচিডেণ্টছ থাকিলে আমি লিখিব লগা হয় পিটিশ্যনত যে মোৰ আৰু কোনো ক্ৰিমিনেল এণ্টিচিডেণ্টছ নাই সেইটোতো লিখিব নোৱাৰে নাই বুলি লিখিব পাৰিলে দিগদাৰ গতিকে এইটো উঠাই দিলে ডেট ইজ দি ৰিফৰ্ম দে হেভ ব্ৰট ইন ইমান বছৰৰ মূৰত প্ৰায় 150 বছৰ লাগিলে এই তিনিখন এক্ট আনিবৰ কাৰণে 150 বছৰৰ মূৰত আমি কি আনিলোঁ অনলি দেয়াৰ ইজ এ অনলি 20% চেঞ্জ ইটছ জাষ্ট এ old wine in a new bottle. Nothing more than that. Our jibur anise changes that could have been brought in a different way. Anibo parile hoy. Etia gutei section bilak change korle, numbering change korle, ফলস্বৰূপে হল কি এই যে দিলে এতিয়া আমি নতুনকে কোৰ্টত আকৌ নতুনকে পঢ়িব লগা হৈছে, নতুনকে বুজাব লগা হৈছে, সেইবোৰ নানাকেও এডেন্ডাম কৰি পেলাই এড কৰি পেলাই এইখিনি আনিব পৰা গ'লহেঁতেন। ইয়াত কৈ আছে তেওঁলোকে যে ইয়েছ, যেটো চেঞ্জেছ আনিছে, কি চেঞ্জেছ আনিছে যে পুলিচে ৰেজিষ্টাৰ কৰিব, হাউ টু ৰেজিষ্টাৰ এ কেছ অফ এ কগনিজেবল অফেন্স। অৰ্থাৎ কগনিজেবল মানে হৈছে কি, অৰ্থাৎ দেখাৰ লগে লগে আমি গম পাওঁ যে এইটো এটা অফেন্স হৈছে। অৰ্থাৎ কোনোবা এখন এক্টত ভাৰতত যিমানবোৰ ক্ৰিমিনেল এক্ট আছে তাৰ ভিতৰত এইটো অফেন্সৰ আওতাত পৰে। ইটছ এন, আমি দেখাৰ লগে লগে বুজি পাওঁ, প্ৰাইমা ফেচি বুলি কয়, দেখাৰ পঢ়াৰ লগে লগে বুজি পাওঁ যে এইটো অফেন্স হৈছে। মোক কোনোবাই এটা চৰ মাৰিলে, মাৰাৰ লগে লগে চৰ মাৰা ইজন অপৰাধ। ইয়াত আৰু বেলেগে মই কৈছোঁ আই এম দি ভিক্টিম। এতিয়া মহিলা 498A তাৰে পানিছেবল পানিছমেণ্ট ইজ দি 3 years। আমাৰ যিটো কয় 498A বুলি আগতে আছিলে, সেইটো হ'ল কি আপোনাৰ মেণ্টেল ক্ৰুৱেলিটি টু দি ওমেন। তাতে ফিজিকেল হ'ব পাৰে, মেণ্টেল হ'ব পাৰে, এণ্ড এবছলিউটলি ইটছ এ বিটুইন দি হাজবেণ্ড এণ্ড ৱাইফে হয় সাধাৰণতে জেনেৰেলি, এণ্ড ইট ইজ হেপেন্স বিফ'ৰ এ ক্ল'জ ড'ৰ এনভাইৰনমেণ্ট বেচিকেলি যদি হয়। ইয়াততো আৰু বেলেগ সাক্ষী নাপায়। চ' এতিয়া এজনী মহিলাই যদি, দুখীয়া মানুহ এজনৰ মহিলা এজনী গৈ পেলাই কয় যে মোৰ হাজবেণ্ডে মোক টৰ্চাৰ কৰিছে মেণ্টেলি অৰ দি ফিজিকেলি, নাও ইট ইজ দি প্ৰিৰগেটিভ অফ দি IO টু ডিচাইড ৱেডাৰ হি উইল ৰেজিষ্টাৰ ইট অৰ নট। বাট ইট ইজ এপাৰেণ্টলি তেওঁ কৈছে যে মোক মাৰপিট কৰিছে। ইয়াতকৈ আৰু কি লাগে? এগৰাকী মহিলাই পুলিচ ষ্টেচনত গৈ কৈছে, জাষ্ট বিকজ ইট ইজ উইদিন দি এম্বিট অফ 7 years, কিন্তু 7 বছৰৰ ভিতৰত আজিকালি কৰি দিলে যে 7 বছৰৰ যদি পানিছমেণ্ট হয় তুমি লগে লগে ৰেজিষ্টাৰ নকৰিবও পাৰা। ইভেন দেন দেৰ ইজ এ প্ৰাইমা ফেচি কেছ, তুমি ছুপিৰিয়ৰ অথৰিটিৰ এটা পাৰ্মিশ্যন লৈ পেলাই ইউ কেন প্ৰলং ইট ফৰ আনাদাৰ 14 days টু এনকুৱাৰী এবাউট ইট। কি এনকুৱাৰী দৰকাৰ আছে সেইটোত? এৰেষ্ট কৰা নকৰা, দেটছ এ ডিফাৰেণ্ট পাৰ্চপেক্টিভ অফ দি ইনভেষ্টিগেশ্যন। আই এম নট অন দেট, বাট ৰিগাৰ্ডিং দি ইনভেষ্টিগেশ্যন এ লেডি হেজ কাম টু এ পুলিচ ষ্টেচন উইথ এ allegation which is prima facie appears that it's a cognizable offense, then also it is কৈছে যে নহয় তুমি এতিয়া ইচ্ছা কৰিলে, অৰ্থাৎ এইটো কাক সময় দিয়া হ'ল? পুলিচজনক সময় দিয়া হ'ল। ফৰ হোৱাট পাৰ্পাছেছ? ফৰ হোৱাট এনকুৱাৰী? এনকুৱাৰীৰ কাৰণে নে দগা পাল্লাখনত তোলা বেচা কোন বেছি সেইটো নিৰ্ধাৰণ কৰিবৰ কাৰণে? এইটো আমি ভাবি চিন্তিব লগা কথা এটা। চ' এনেকুৱা ধৰণৰ চেঞ্জেছ কিছুমান আনিছে সেইবোৰ। দেন সেইকাৰণে মই কৈছোঁ দি পলিটিকেল ইণ্টাৰফাৰেঞ্চ। ইয়াতে আকৌ পলিটিকেল ইণ্টাৰফাৰেঞ্চ বুলি ক'লে আকৌ আন এটা কথাও মই ইয়াতে কৈ থোৱা উচিত। সুপ্ৰিম কোৰ্টতে হওক বা হাইকোৰ্টতে হওক, এই যে ডাঙৰ ডাঙৰ পলিটিকেল লিডাৰ্ছ তেওঁলোক যদি নহ'ল হয়, কিন্তু ইয়াত কৈছে যে আমাৰ হেৰিয়ে কৈছে যে তেওঁলোকতকৈ দুখীয়া মানুহৰ কেছবোৰ চাব লাগে। মই কিন্তু আন ধৰণে কম, কি কাৰণে? তেওঁলোকৰ কাৰণেহে ডাঙৰ ডাঙৰ জাজমেণ্ট হৈছে সুপ্ৰিম কোৰ্টত, নট ফৰ দি প'ৰ পিপল। আপোনালোকে যদি হিষ্ট্ৰীটো চাই, চবতকৈ যিটো হিউমেন ৰাইটছ আমাৰ কথা কওঁ, আমি যে কওঁ যে নহয় আমাৰ এইটো ভায়লেশ্যন হৈছে, হিউমেন ৰাইটছ ভায়লেশ্যন হৈছে, মোক নেচাৰেল জাষ্টিছ মই পোৱা নাই, অৰ্থাৎ মোক শুনা নাই এডুকেটলি, সেইটো কাৰ কেছত আহিছিল জানেনে? প্ৰথম ইমান ডাঙৰকৈ চবতকৈ ডাঙৰ এজন মানুহ, সেইটো হ'ল মেনকা গান্ধী, তেওঁৰ কেছতহে ডিচাইড হৈছিল। প্ৰাইমা ফেচি কেছত কেছ এটা কোৱাছ কৰি দিব পাৰে, ট্ৰায়েল নোহোৱাকৈ শেষ কৰি দিব পাৰে কিছুমান কেছ, যদি কেছটো মেকআউটে হোৱা নাই। সেইটো ক'ত আহিছিল? ভজনলাল, চিফ মিনিষ্টাৰ, ডাঙৰ মানুহ। তেনেকুৱা ধৰণৰ চব আপুনি যিমানবোৰ ডাঙৰ মানুহৰ কেছ দেখে, সেই সকলোবোৰতে ল পইণ্ট কিন্তু ডিচাইড হৈছে, আৰু সেই ল পইণ্টবোৰে কিন্তু আচলতে পিছত গৈ পেলাই সকলো মানুহক সমানে, সকলোৱে পিছত ভৱিষ্যতে সেই ল পইণ্টৰ দ্বাৰা সেই, কিন্তু তেওঁলোক যদি নগ'ল হয় সুপ্ৰিম কোৰ্টলৈ, এই ল পইণ্টবোৰ ছেটেল নহ'ল হয়। যদি মেনকা গান্ধীয়ে চেলেঞ্জ নকৰিলে হয় লাইচেঞ্চৰ কাৰণে, এইটো কি দিবৰ কাৰণে, পাছপৰ্ট দিবৰ লাগিছে, পাছপৰ্টৰ কাৰণে সৰু এটা কথা, কিন্তু গৈ পেলাই ডাঙৰ জাজমেণ্ট এটা হ'ল যে নেচাৰেল জাষ্টিছ অপৰচুনিটি দিব লাগে নে নাই। চ' এইটো মেনকা গান্ধীৰ কেছত AR আনটোলে চিফ মিনিষ্টাৰ আছিল, তেওঁৰ ক্ষেত্ৰত বহুত ডাঙৰ ডাঙৰ জাজমেণ্ট হৈ গ'ল তেওঁৰ বিষয়ত, স্পীডি ট্ৰায়েলৰ পৰা আৰম্ভ কৰি অলৰেডি ৱাজ AR আনটোলে চিফ মিনিষ্টাৰ আছিলে, ভজনলাল চিফ মিনিষ্টাৰ আছিলে, তাৰপিছত তেনেকুৱা আমাৰ প্ৰকাশ সিং বাদল, তেওঁৰ ক্ষেত্ৰত ডাঙৰ কেছ হৈছে লালু প্ৰসাদ তেওঁৰ ক্ষেত্ৰত ডাঙৰ ডাঙৰ সুপ্ৰিম কোৰ্টত লেণ্ডমাৰ্ক জাজমেণ্টছ অল ইন বিগ কেছেছ বিকজ দে কেন এফৰ্ড টু গ' টু দি সুপ্ৰিম কোৰ্ট আৰু ডাঙৰ ডাঙৰ উকিল হয় আৰু ডাঙৰ ডাঙৰ ল পইণ্ট ছেটেল হয় ইটছ ভেৰি আইৰনিকেল Then regarding the pendency, the lots of pendency in the cases, yes, amar jikhon dekh iman khini manu, definitely pendency hobo. There is no doubt about it. But again, pendency, how to curtail the pendency? Curtail the pendency is then again the ironical thing that moi jitu koichu prothom obosthat that the person who don't have the expertise, even amar khetrot aji moi as a lawyer, মোক যদি কোনোবাই ৰাস্তাত ৰোড ৰেজ এটাত হয় মোৰ গাড়ীখন কোনোবাই খুন্দিয়াই মোৰ যদি মাৰপিট মাৰে মই কিন্তু মাৰপিট নকৰোঁ বিকজ আই ন' দি ল যে মই যদি মাৰপিট কৰোঁ উল্টাই আই মে বি প্ৰচিকিউটেড টুমৰো হি মে লজ এন FIR আই মে বি ইন ট্ৰাবল চ' মই লটো জানাৰ পিছত এইটো ডিচিশ্যন লৈছোঁ কিন্তু আগতে কি হৈছে মোৰ নিজৰ ক্ষেত্ৰত মই কওঁ ইট ইজ নট এইটো ভেলাঘৰ সাজোঁ আমি বিহুত ভেলাঘৰ খাওঁতে ৰাতি চুৰ কৰিব গ'লোঁ চুৰ কৰি এখন বেৰ দাঙি মোৰ আৰু বন্ধু এটাই আহি আছোঁ ৰাতি 11টা বজাত কথা বেলেগ ঘৰৰ বন্ধুৰ বেৰে দাঙি লৈ গৈ আছোঁ সিপিনৰ পৰা এই বাইক চলাই পেলাই আমাৰ ওচৰৰে পুলিচ থানাৰ যিজন OC হি ৱাজ গোয়িং টু হিজ হাউচ আমি ভাবিলোঁ সি আমাক ধৰিব আহিছে নাও হোৱাট টু ডু আমি ভাবিলোঁ বুধিয়ক সি আমি অহা আগতে গোটেই মস্ত বেৰাখন তাৰ ওপৰত পেলাই দিলোঁ পেলাই দি তাক যি কৰিব লগা আছে কৰিলোঁ আই নাও গোয়িং টু ডিটেইলছ আৰু সেই সময়ত দি আণ্ডাৰ দি বহুত কিবা প্ৰভাৱতো হয় ৰাতিৰ চ' সেইবোৰ অৱস্থা আমি কৰিলোঁ কিয়নো ডেট মই স্কুলত ঠিক পাছ কৰিছোঁ কিন্তু মোৰ আই হেভ নো নলেজ এবাউট দি ল হোৱাট ইজ অফেন্স মোৰ সেইটোৱে মোৰ নলেজত নাই হোৱাট ইজ অফেন্স অল এবাউট চ' মই লগে লগে মই কেনেকুৱা আচলতে ডাঙৰ ক্ৰাইম এটা কৰিছোঁ নট অনলি মই চুৰ কৰিছোঁ বাট অলছ' মই এজন পাব্লিক ছাৰ্ভেণ্টক অন অফিচিয়েল ডিউটি মই তেওঁক মাৰপিট কৰিছোঁ দেট ইজ এনাডাৰ অফেন্স আই হেভ কমিটেড 2 অফেন্স ইন দ্য ছেইম কজ অফ একশ্যন আণ্ডাৰ দ্য ছেইম নাইট মই তাক মাৰপিট কৰি আমি আন্ধাৰৰ সুযোগ লৈ পলাই গ'লোঁ দেটছ এ ডিফাৰেণ্ট ইছ্যু মোক ধৰিব নোৱাৰিলে বেলেগ কথা কিন্তু আজিৰ দিনত মই সেইটো কাম নকৰোঁ কিয় নকৰোঁ আই ন' দি কনচিকুৱেঞ্চেছ চ' এই যে কনচিকুৱেঞ্চটো কেতিয়া শিকিব লাগিব ল'ৰা ছোৱালীয়ে মই কিয় শিকা নাছিলোঁ বিকজ মোৰ পাঠ্যপুথিত ক্ৰাইম কি বস্তু ক'তো উল্লেখেই নাছিলে আজিও নাই ইটছ এ ছাৰপ্ৰাইজিং এতিয়া মিত্ৰা বহি আছে মিত্ৰাই পঢ়ায় জোনালীয়ে পঢ়ায় তেওঁলোকে ক'ব পাৰিব নেকি কোনখন পাঠ্যপুথিত ক্ৰাইমৰ ডেফিনেশ্যন আছে কেন দে চে যে ৱেৰ ইজ দি ডেফিনেশ্যন অফ দি ক্ৰাইম কোন ছেকশ্যনত কেতিয়া ক্লাছ 8ত লাগে 7ত লাগে হোৱাট ইজ ক্ৰাইম কিয় কৰিব নালাগে ক্ৰাইম হোৱাট ইজ অফেন্স সেই সৰু সৰু বস্তুবিলাক আমাক কিয় শিকোৱা নহয় সময়ত সেইকাৰণে যে এওঁলোকে কৈ আছে যে ক্ৰাইম ডিটেক্ট কেতিয়া হ'ব যেতিয়া মই জানিম যে দিছ ইজ অফেন্স দেন উইল কাম দি ডিটেকশ্যন ফাৰ্ষ্ট অফ অল মোৰ সৰু সৰু নলেজত সেইবোৰ আহিব লাগিব সৰু কালচোৱাত যে দিছ ইজ ডিটেকশ্যন দিছ ইজ ক্ৰাইম যে এইটো মই কৰা উচিত নহয় ইয়াৰ ফলস্বৰূপে অমুক হ'ব ল'ৰা ছোৱালীবিলাকে এইবোৰ কথা নাজানে ফলস্বৰূপে তেওঁলোকে ভুল কৰে তাৰপিছত ভুল কৰাৰ পিছততো শাস্তি সেইটোতো বেলেগ কথা আৰু ক্ৰিমিনেল কথাটো এনেকুৱা এটা ডাঙৰ বস্তু দ্য ক্ৰিমিনেল অফেন্স চিভিল অফেন্স ইজ ডিফাৰেণ্ট চিভিল লিটিগেশ্যনছ ইটছ এ ডিফাৰেণ্ট বাট দি ক্ৰিমিনেল দেৰ ইজ ন' অপশ্যন আইদাৰ ইউ আৰ ইনচাইড অৰ আউটচাইড এপাৰ্ট ফ্ৰম ডেট দেৰ ইজ এ কি যে এই যে মই সোমালোঁ আইদাৰ ৰাইটলি অৰ ৰংলি মোক যদি জেইলত হ'ল বা মোৰ এগেইনষ্টত কেছ হ'ল নট অনলি মি my whole family is going to suffer. Family after family, my son, my daughter, everybody is going to suffer. How? The people will point it out that this man was once prosecuted or he was once inside the custody, maybe rightly or wrongly. Hetur uttor kune dibo. So, ei je detection to, ami prothomoto aste crime, what is the crime? Ei horu horu kisman crime. আমি শিকিব লগা হয় পিছৰ অৱস্থাত মই আজি শিকিছোঁ যে আজি এইকাৰণে মই কাৰো ওচৰত হাত নতলোঁ মোক লাগে সেই যে মহাত্মা গান্ধী গ'ল যে এগালত মাৰিলে এগালত মাৰি দিব মই এতিয়াহে এইটো ফ'ল' কৰোঁ কিন্তু তেওঁ আগতেই কৈ থৈছিলে কিন্তু সেইটো মই সেই ৰিগাৰ্ডত নহয় মই আজি আই ন' বিকজ দি কনচিকুৱেঞ্চেছ যে আই শুড নট ৰাদাৰ আই উইল গ' টু দি পুলিচ ষ্টেচন এণ্ড আই লজ এন FIR এগেইনষ্ট দি পাৰ্চন আই উইল নট মই লটো হাতত নলওঁ কিন্তু আগতে হ'লে because of the rush of blood, maybe rush of blood or ক্ষেত্ৰতো বহুত ধৰণৰ offenses হৈ থাকে. Next, আমাৰ ইয়াত again the judges of quality, যিটো আমি কৈছোঁ, আমাৰ দেশতখনে এখন দেশ, তাৰে বহুতখিনি judges আছে, they basically has never visited the trial court. They have never seen the trial court. They don't know the procedure of the trial court. One of me, তেওঁলোকে এটা দুটা হয়তো গৈছে, because of their long duration in the High Court or the other courts, they have been elevated to the High Court or later on the Supreme Court. তেওঁলোকে হয়তো entire time খিনিয়ে তেওঁলোকে হয়তো constitutional case কৰিয়ে কটাই দিলে, or civil litigation কৰি কটাই দিলে. Now all of a sudden, they are dealing with the criminal cases. And what is the criminal cases? Criminal cases, there is no option, there is no third option for them. Either you are inside or you are outside. And the person has no knowledge about the criminal cases. He is deciding the fate of a person. Orthat, without the expertise, hey মানুহজনৰ basic expertise নাই criminal law to deal কৰিবৰ কাৰণে. অৰ্থাৎ তেওঁ হয়তো সাধাৰণ MBBS doctor, but he is dealing with a কি হয়তো pancreasৰ operation কৰি আছে. So, and see the irony, and you are helpless. তেওঁৰ হাতত, the judges, the High Court judge, he will now decide. The Supreme Court does, he has no expertise in the criminal law. Sitting on a chamber, he will not decide that this is the law. এইটো ধৰণে হ'ব লাগে. ফলস্বৰূপে হয় কি বহুত ক্ষেত্ৰত লেকুনা থাকি যায়, যিবিলাক practically impossible কথা কিছুমান হৈ থাকে. Now they have brought in changes. কিছুমান কাৰণে they have brought in changes. কিন্তু সেই changes বিলাকৰ কাৰণে যিবিলাক আনিছে, এতিয়া হ'ল কি আপোনালোকে এই changes হয়তো আপোনালোকে will be very surprised. মই খুদা দুটামান কথা কম, then we will go for the interaction section. What are the changes? আগতে এটা আছিল unnatural offenses. সেইটোক আমি অৰ্থাৎ কিছুমান sexual offenses, unnatural sexual offenses. Supreme Court a judgment dile je to consenting male holeo, jodi consenting hoy, that's very important, then it's not an offense. Ebar amar teluke ei gute bostute uthai dile. Etia ajir dinot unnatural offense bula bostu nai. ফলস্বৰূপে হৈছে কি ইমান ডাঙৰ এটা ভুল আমি ইমান বছৰৰ মূৰত আকৌ কৰিলো. আচৰিত, very surprising. আজিৰ দিনত নাই এইটো অফেন্সটোৱে নাই. সুপ্ৰিম কোৰ্টে কিন্তু অফেন্সটো নাইকিয়া কৰা নাছিলে, তাৰ পাৰ্ট এটাহে নাইকিয়া কৰিছিলে, তাতে কনচেণ্টিং হ'ব লাগিব. যদি কনচেণ্টিং নহয় কি হ'ব আজিৰ দিনত? there is no offense. আজিৰ দিনত যদি মেইল এজনক আন এজন মেইলে ৰেপ কৰে, there is no offense. Surprising, this new act they have brought in. So these are the changes they have brought in. তাৰপিছত তেওঁ কৈছে এনেকুৱা কিছুমান চেঞ্জেছ আনিছে আচৰিত ইমান বছৰ মূৰত. The changes they have brought, আগতে আমাৰ যিটো কৈছে যে ক্ৰিমিনেল কেছ কৰিবৰ কাৰণে there are 3 options. There's one option was the filing the criminal case directly in the court. কোৰ্টত আমি সিধাকে পুলিচত নগৈও কিছুমান কেছ কোৰ্টত আমি দাখিল দিব পাৰোঁ আমি যদি ইচ্ছা কৰোঁ থ্ৰু লয়াৰ. সেইটোত আকৌ আনি দিলে কি এবাৰ যে কোৰ্টে তোমাৰ কেছটো লোৱাৰ আগতে he will issue, মই exactly কথাকেইটা wordকেইটা ইউজ কৰিছোঁ, notice to the accused to explain. কেছটো কিন্তু লোৱাই নাই দেই তেতিয়ালৈকে, অৰ্থাৎ কগনিজেন্স লোৱা নাই, অৰ্থাৎ কেছটো গ্ৰহণ কৰা নাই কোৰ্টে এজ এ অফেন্স বুলি. কিন্তু নোটিছ কাক দিব? টু এন একিউজ. ইপিনে একিউজ হোৱাই নাই, কেছে লোৱা নাই কোৰ্টে, কিন্তু নোটিছ কাক দিব? একিউজক দিব. হু ইজ নট এন একিউজ, নট ইউ বিফৰ ইউ, তুমি লোৱাই নাই কিন্তু একিউজ কৰিব. এনেকুৱা চিলি মিষ্টেক 150 বছৰৰ মূৰত আমি কৰিছোঁ. এণ্ড আমি এতিয়াও ভাবিছোঁ যে বাহ আমি খুদা ইলেক্ট্ৰনিক মাধ্যম অমুক ভাল হ'ব তমুক ভাল হ'ব, ঠিক আছে এইবোৰ হ'ব, কিন্তু বেচিকবোৰ ক'ত গ'ল? বেচিকবিলাকে নাই দেখোন তোমালোকৰ, বেচিকতে ইমানবোৰ ভুল, সাধাৰণ কথা এইবোৰ. আৰ্টিফিচিয়েল ইণ্টেলিজেন্সৰ কথা কওঁ, বাট উই ডোণ্ট হেভ দি বেচিক ইণ্টেলিজেন্স ইটছেল্ফ appears to be. We are all artificial actually. সেইকাৰণে কি জানি artificial intelligence. Speedy trial এতিয়া কৰিব লাগিব, So speedy trial or ক্ষেত্ৰত মই কৈছোঁ যে speedy trial কৰিবৰ কাৰণে first of all the judges যিবিলাক appoint হয় তেওঁলোকক যেতিয়া chief justice allot কৰে allot কি ধৰণে কৰিব লাগে তেওঁলোকৰ যিটো বেকগ্ৰাউণ্ডটো চাব লাগে এক্সপাৰ্টিজটো চাব লাগে যে তেওঁ এইটো বিষয়ত সোনকালে সমাধান কৰিব লাগে এজন সিভিল জাজক যদি ক্ৰিমিনেল বেঞ্চ এখন দি থৈ দিয়ে মাহৰ পিছত how he will solve this is what is happening this is reality আমি সেইটো চকু বন্ধ কৰি থাকিলে নহব these are the facts to be this আমি সেইবোৰ কথাই পাতিব লাগিব so with that probably মই এইখিনিতে শেষ কৰিলোঁ আৰু যদি আপোনালোকৰ কিবা প্ৰশ্ন থাকে I'll try to answer it as possible thank you
Thank you, Mr. Bora. Now I open the floor for your questions. Yes.
Good evening. My question to Mukul Saikia, sir. Many times we have seen that police abuse of power, like unwarranted arrest, wrongfully search, wrongfully imprisonment, and custodial deed and custodial violence. Apuni jehetu as a mane retired police officer ki kobo ei khetra apuni ar apunar chakori kalot jodi kiba eneko experience ase please share with us
use aru abuse ei duta kotha ase ta use abuse jetie eta ক্ষমতাৰ বেছি ব্যৱহাৰ হয় তাক abuse kobo aru jodi properly loi goi thake hetu use hol to definitely police ot abuse of power আছে physical torture আছে নথকা নহয় custodial death হৈছে তেনেকুৱা বহুত হৈছে এইবিলাকৰ ওপৰত ইনকুৱাৰী ইনিচিয়েট হৈছে আৰু বহু দুখিক অফিচাৰক ইতিমধ্যে সাসপেন্ডো কৰা হৈছে কিছুমান ক্ষেত্ৰত মোৰ যদি পাৰ্সোনাল এক্সপেৰিয়েন্স এটা বিচাৰে কিছুমান কেছ এনেকুৱা হয় কিছুমান কেছ এটা মানুহ বহুত যেতিয়া হাই থানাত আহি যায় ৰাতি সাজেন ভাল মানুহ এটা আৰু ৰাতি ৰাখি দিম বুলি কয় হি অলপ ধতুৱা মানুহ যদি হয় হি মেণ্টেল শক পায় তাক মাৰিব নালাগে মেণ্টেল শক পায়ো বহুত মৰে থানাত মৰিলেই যে কাষ্টডিয়েল টৰ্চাৰৰ ওপৰত ডেথ হৈছে এনেকুৱা নহয় প্ৰতিটো কেছেই কিন্তু মই এইটো ডিনাই কৰা নাই যে টৰ্চাৰ কৰি ডেথ হোৱা নাই যিটো গোলাঘাটৰ আবাস্তি কেছ এইটোতো কোৰ্ট কেছ চলি আছে তেওঁৰ এগেইনষ্টে এতিয়া খুব সম্ভৱ এইটো কোনোবা এটা কোৰ্টে কনভিকশ্যন দিছে তাৰ পৰা ক'ৰবাত লৈ গৈছে থানাত মানুহ মৰে মোৰ চাকৰি লাইফতো মৰিছে কি হ'ল এজন মানুহ মই আনি থৈ গৈছিলোঁ তেতিয়া মই প্ৰফেশ্যনেল লাৰ্ণাৰ মানুহজন ৰাস্তাত পালোঁ পাই দা এখন লৈ ৰৈ আছিলে ৰৈ পেলাই মই থানাত আনি থৈ গ'লোঁ তেতিয়া ওচিয়ে মইতো একো নাজানো ওচি ক'লোঁ আপুনি চাই চিতি আৰু এৰি দিব মই নীতি নিয়মো নাজানো কেনেকৈ এৰিব লাগে প্ৰথম DSP প্ৰফেশ্যনাৰ মই ওচিয়ে ভাবিলে ইয়াক যেতিয়া আনিলেই তো মই ইয়াক অলপ অৱস্থা ভাল ঘৰৰ মানুহ কিবা এটা উলিয়াওঁ তাক ক'লে তোক DSP ছাৰে যেতিয়া প্ৰফেশ্যনত আছিলোঁ অলপ ষ্ট্ৰিক্টটো আছিলোঁ অলপ ৰাস্তাত মানুহ ভয় কৰিছিলে দুই একেবাৰে তেতিয়া ডেকা বয়সত ক'লে এই DSP ছাৰে আনিছে যেতিয়া তই মৰিলি আৰু তোক মাৰিব আজি ভালকৈ তো কিবা কিবি কৰি যেনে তেনে ওলা ওচিয়েও ভয় খোৱালে আৰু তাৰ মূৰত দাখন লৈছিলে তাক এটা মানুহে কাটিছিলে ইয়াত মূৰত 7টা চিলাই পৰি আগতেই আছিলে অলমষ্ট 7টা চিলাই পৰি আছিলে সি যোনটো মানুহে কাটিছিলে তাক কাটিবলৈ দাখন লৈ ৰৈ আছিলে তাতে তেনেকুৱাতে পালে মই বাছিলে সাব ইন্সপেক্টৰো আছিলে পালে সি আহি পেলাই থানাত সি মৰি থাকিলে সেইটো তাৰপিছত এনকুৱাৰী হ'ল প্ৰপাৰ পষ্টমৰ্টেম হ'ল এই কাষ্টডিয়েল যেতিয়া কাষ্টডিত মৰে পুলিচে ফেক্ট লুকুৱাব নালাগে ইট শুড বি অপেন টু অল সকলোৱে আহি চাওক মিডিয়া হওক মেডিকেল কৰা হওক মেজিষ্ট্ৰেট এনকুৱাৰী হওক যেতিয়া এটা ফেক্ট কনচিল কৰা হয় তেতিয়া ডাউট হয় মানুহৰ গতিকে কনচিল কৰিব নালাগে যদি প্ৰকৃত সত্যটো হয় তেতিয়াও কনচিল কৰাটো পুলিচে উচিত নহয় ইমিডিয়েট জনাব লাগে নেশ্যনেল হিউমেন ৰাইটছ কমিশ্যনক তুৰন্ত দিব লাগে জনাব লাগে ষ্টেট হিউমেন ৰাইটছ কমিশ্যনক জনাব লাগে সুপিৰিয়ৰ অফিচাৰক জনাব লাগে এইখিনি গোটেইখিনি কথা ঠিক আছে থেংক ইউ
My question is to Kutur sir.
I just want to add on search and seizure. New law, there's a significant improvement. In fact, in my view, that's the best thing BNSS has done. Section 105, where it says that for every search and seizure, when police conduct, it has to be covered by audio, video, electronic means. It creates lots of challenge for police functionaries, but they have started already doing it. So chances of manipulating search and seizure, writing seizure list at the police station, calling the witness to sign it, all those days gone. Now, when they do search and seizure, entire proceeding has to be under the surveillance of audio, video, electronic means, as per 105 of the BNSS. And also 185 says this entire videography, etc., need to be sent to the magistrate within 48 hours. So some check is there on that, definitely. It's a really good provision. Where they could have added, and they have not added it, in the old law, section 51, 52, like when a police arrests someone, after arrest, when search the body and then seized, that search and seizure is not covered. But the thing which are there in the chapter of search and seizure, impliedly when police sent notice under 91 earlier, now become 94, to bring some document, and they seize it. So that seizure, or when the police do search with warrant or without warrant, all those things are covered. It has to be covered under the surveillance of audio, video, electronic means. So it's an excellent improvement in the new law.
I got one added question. Do you have the data of custodial death recently? There was a downward trend, but now again it has gone up.
No, it's
175.
It's up. So, like exact data, normally the NCRB data is very confusing. That's not exact data. So, for understanding custodial data, NHRC publish every year data. But from last 2 years, I think they are not publishing it also.
Yeah,
so
2022 was the last.
Gujarat is the highest, it is 80.
All total,
Second
India.
position is UP.
UP.
Third position is probably Haryana.
So about 175 custodial death has happened. That's a very question of concern. Yes, next question, please.
Good evening, everyone.
1 second.
Esteemed panel and everyone present here. I am Dr. M. Hazarika from Cotton University. Well, my question is with regard to juvenile justice under the ambit of India's criminal justice system. And my question is the current approach to juvenile justice effective in rehabilitating children, young offenders? And what about addressing the severity of certain crimes committed by children, young offenders? This may be answered by any one of you. Thank you.
Exact from data saying very difficult because we don't find like, again it varies from the state to state the practices. So far laws are concerned, laws are very clear. When we, very interestingly, when we looked at the law, Juvenile Justice Act 2015, and where the quantum is says that if a child is found guilty, like after the trial, what to do? And it says A, B, C, D, section 18 probably, so 18 A, B, C, D, E, F, G. The clause G says a child can be sent, child who committed offense, the child can be sent to a special home for a period of 3 years. But this is the G part. You have A, B, C, D, E, F, which talk about all alternative to punishment. So it can be social work, it can be they are giving to vocational training institutions, it can be anything social work called, like now the community service has been added in Nyaya Sanhita. The same thing could be, it was there in the JJ Act also. So far laws are concerned, there's an enormous power vested with Juvenile Justice Board to follow alternative to punishment and follow even the restorative justice systems. Whether they follow in reality, my feeling of many research which I found, no. So there's a huge gap between the law or expectations and the delivery. That gaps exist. So far Commission of Heinous Crime is concerned, now 2015 Act has made changes where they says if the child is between 16 plus and below 18 and the crime is heinous, then in those circumstances, JJB will take a call after assessing two things. Whether the child has a knowledge, like about the knowledge about the offenses and the impact of the offenses. If both the answer is yes, then the JJB can send the child to children court for the trial as an adult.
And there also they laid down some protection that you cannot give death penalty, you cannot give life imprisonment. Those exceptions are there. But the child can be tried there. So those safeguards are there. My personal views are, howsoever heinous crimes are there, if a child commit offenses, as a society we have failed, and for our failure you don't want to punish one person. Every child who commit offenses, they are the children who are from poor family, there are children who are living in the roadside, without any shelter, without any home. As a state, what we have done? It's our failure that we have not able to provide them free educations. Free everything. So if a child commit offenses, the target should be people who are associated with the child. So there are always a child, then some adult offender. You punish them. But for the children, there is a responsibility which states should also take, because we have failed in our due diligence responsibility to ensure the safety of the child. Nevertheless, 2015 Act says they can be punished as an adult when they transfer to the children court, and children court can give punishment. That provision is there.
I hope this answers your question. Yeah.
So my question is, today's this pertinent discussion is regarding reforming India's criminal justice system. So we all know that FIR is the FIR is the information first in point of time before the police, where there is a disclosure of prima facie case, then FIR must be registered. And after based on which investigation was undertaken by the police. Does it really happens by bringing these 3 new laws, that is BNSS, really bringing these 3 new laws, is it possible for the present system to bring the criminal justice, those who are affected, those are the victims of the circumstances? My question to Honorable the Senior Advocate, Shri Angshuman Bora, sir.
So my question is, look, if there is a prima facie case, there should not be any scope for any inquiry. I don't know why it has been incorporated, why this safeguard is, I'll call it a safeguard for the accused for 14 days. Otherwise, as my learned friend has already said, that there are numerous judgments of the Supreme Court that when there is a prima facie case, you are bound to register the FIR. There is no second thought. There cannot be any. You are bound to. Now, with the new act, you can prolong it for the 14 days for the sake of inquiry for the alleged offences. It may be good, I don't know, the time will say, but right now my prima facie view is that this provision, rather, it will create a complication, it will give a scope for the police officer to negotiate. That is my prima facie view. So, I think this provision, definitely the Supreme Court is there to decide on this particular point of law under 141 of the article. I think some amendment is necessary in this particular provision.
More question to deliberationত কৈছিলে যে মই কোনো স্পেশালিষ্ট নহয়, কিন্তু পুলিচৰ যিখিনি লেকুনা থাকে সেই লেকুনাৰ ফায়দাখিনি লৈ মই আসামিক খালাস কৰোঁ। তাৰমানে এতিয়া কথা হ'ল, যেতিয়া ইনভেষ্টিগেশ্যন হয়, পুলিচ ইজ টু ফাইণ্ড আউট দ্য আনবাৰ্নিশ্ড ট্ৰুথ থ্ৰু ইনভেষ্টিগেশ্যন। গতিকে ইনভেষ্টিগেশ্যনত যদি লেকুনা থাকে, ইফ দে আৰ বিন এংগেজড ইন সাম আদাৰ ডিউটিজ লাইক VIP ডিউটি এণ্ড অল এটচেট্ৰা, ৱৰ্কলোড saying just that there are some other places, তেতিয়াহ'লে এই আমাৰ ক্ৰিমিনেল জাষ্টিচ ছিষ্টেমটো আমি ডেভেলপ কেনেকৈ কৰিম? যে আজি 150 বছৰ পিছত আমি 3টা নতুন আইন পালোঁ। এই আইনৰ জৰিয়তে তাৰমানে কেৱল 20%হে ইয়াতে হেৰি হৈছে, আৰু সেই পুৰণা বটল নতুন বটলত পুৰণা মদ সেইটো ভৰোৱাৰ নিচিনাই হৈছে। গতিকে একচুৱেলি যদি আমি এইটো ৰিফৰ্ম কৰিব লাগে, তেতিয়াহ'লে আমাৰ কৰণীয় কি আছে?
মোৰ পিছত প্ৰথম কথা মই এটাই ক'ম, কৰণীয় হ'ল specialization. বিশেষকৈ criminal justice systemত specialization is the must needed thing. যদি যিবোৰ জাজ আছে তেওঁলোক স্পেচিয়েলাইজ হ'ব লাগে আন দেশত জাৰ্মানীৰ নিচিনাকৈ ইয়াতো মোৰ বোধেৰে 2খন হাইকোৰ্ট হ'ব লাগে 2খন সুপ্ৰিম কোৰ্ট হ'ব লাগে one for the criminal offenses, one for the rest of the constitution matter হওক বা civil matters. For the criminal there should be a different because we are deciding a fate of a public, a person. আৰু এইটোত এটা ডাঙৰ ষ্টেক ইনভলভ হৈ থাকে হোল ফেমিলি ইজ নট ইনভলভ বেমাৰ হ'লে মানুহজনৰ নিজৰ বেমাৰ হয় নিজে চাফা কৰে তেওঁ সময়ত কি হয় গোটেই ফেমিলিটো সাংঘাতিক ইনভলভ নহয় কিন্তু ইয়াত হয় কি মই এজন মানুহৰ যদি কিবা কাৰণে মিছাকৈ হ'লেও কনভিকশ্যন হয় বছৰৰ পিছত বছৰ তেওঁ গোটেই ফেমিলিটো ইনভলভ হৈ থাকে সেইকাৰণে মই কৈছোঁ যে ইমান এটা চেনচিটিভ কথা আৰু কোনবোৰ মানুহে এইটো ডিচাইড কৰে তেওঁলোকৰ এক্সপাৰ্টিজ কিমান বছৰ মই সেইকাৰণে কৈছোঁ আমাৰ সাধাৰণ বেমাৰ এটাত মই এজন স্পেচিয়েলাইজ ডক্টৰৰ ওচৰত যাওঁ ৱেৰেজ এনেকুৱা এটা ছ'চাইটিৰ ব্যাধি এইবোৰ অফেন্সবিলাক কিন্তু ব্যাধিহে দেই দিজ আৰ অফেন্সেছ ইটছ এ ব্যাধি এই ব্যাধিটো নিৰ্মূল কৰিবৰ কাৰণে আমি কাৰ ওচৰত যাওঁ ডু দেট হেভ একচুৱেলি দি চেম এক্সপাৰ্টিজ এজ দি ডক্টৰ্ছ হেভিং মাই এনচাৰ ইজ নো দ্যাটছ আই এম ছেয়িং there should be the separate Supreme Court or the High Court for the criminal offences that will serve the not only the speedy justice and the actual justice. যেটো আমি কওঁ যে জাষ্টিস অকল কৰিলেই নহ'ব জাষ্টিস মানুহৰ আগত উপলব্ধ হ'ব লাগিব মানুহে দেখিবও লাগিব যে জাষ্টিস has been actually been done. তেতিয়াহে হ'ব. Thank you.
I hope this answers your question. Any other? হয় আপুনি ক'ব.
My question is to Khan sir. Is there any reforms taken in new laws to prevent child abuse?
Sorry, say again.
Child abuse.
Child abuse.
Okay, new law has talked about many things, like in the sense that when we say child abuse, again, very broad term. Child sexual abuse, yes, the penal provision which was earlier has been further refined, is there in the new law. General abuse cases are there. For example, now in the new law, they have inserted a new chapter called Offences Against Women and Children. And one section, I don't teach IPC, I don't exactly remember the sections, is in the beginning of the chapter. After rape, etc., then the child comes, where it says that any children who used by adult group member, which normally happen, like armed group, they use children. They use children for the career, etc. So these are general provisions where anyone who uses the children for the purpose of committing offences, they all can be prosecuted. So it's excellent provisions. It's not only the child abuse in any case cover. Earlier also, the same thing has been done. One addition is when they use child for the purpose of committing an offences. So target is not those children, target are the people who are behind them. And that's what I said earlier, many people, now the criminals know JG Act much better than us. So they hire children for committing crime. And that's what the provision is, it's excellent. It was earlier in JG Act, but not that extensive provisions. Now the Nyaya Sanhita provision is much better on that regard. Yes.
Very good evening to all. I welcome all the speakers, and they have spoke very well. Thank you to Indian Policy Institute for organizing such a beautiful panel discussion on the reforming of Indian criminal judicial system and justice system. I think this kind of discussion is very much required in the present scenario. I have 2 questions and 2 requests, so I will not take much time. My question is to Mr. Khan, Mr. Sarfaraz Khan. Sir, after independence, we have seen in India various criminal justice system reform committee has been formed, like Malimat committee report, Madhav Memon committee report, and there are a lot of Supreme Court directives on police reforms and judicial system reforms. Can you please illustrate us what exactly preventing our authorities, especially the governments, various governments, since after independence, from implementing this kind of directives or recommendations? Number 1 question, sir. Number 2, sir, that you have already mentioned about the new 3 enactments like BNS, and BSA. Do you think that after the recent 3 enactment, can help our India's criminal system in the reforming, the way we are thinking, the way we are discussing today? What is our expectation, and what is at what level we can expect that this three enactment can help us into our thinking? Number second questions. My request to Mr. Pankaj Das, the President of the Indian Policy Institute, to organize this kind of discussion in school level or college level. As Honorable Senior Advocate Mr. Angshuman Bora has said in his speech, knowledge is very much required, especially about law and the offense. So it has to be start from the school level. Although our education system has not incorporated or not taken the syllabus about the Indian legal system or offenses. So can we take, like Indian Policy Institute, can we take this initiative, especially in Assam, from school level, at least our next generation can be educated about the legal system and the legal offenses, what we are facing. And the second request to Mr. Angshuman Bora, my special thanks to you, sir. You have spoken from your hearts and from your experience. You have given us all the revision about the entire criminal system of India and Assam. Sir, please use the way you speak today, you speak every day, wherever you get the chance. You are our boys, be inside the court or outside the court. You must speak, sir. And the same things are happening, we are practicing in High Court or in trial court, we are facing the problem. Like we have seen about the rostering. A person, a judge he has given the charge of a criminal bench. He has no idea about the criminal laws. Basic ideas are not there. Many times we have seen, Honorable Sir has pointed out this inside the court also, directly to the judges. But I think he should speak. We had a legal luminary who is no more with us. As a very renowned lawyer, he expired a few years back. Dotto sir, Nil Dotto sir, who was one of the boys for the young advocates in Northeast, who always stood for us. We experienced a lot of difficulties inside the court, but no one is there to speak for us. Only Nil Dotto sir was there. I remember there are occasions he mentioned the same before the judges, and after that we got the result also. So sir, you please speak whenever you get the chance. Be inside the media, wherever there is a seminar, you please speak for us. We are with you. Sir has mentioned, sir, these are very much practical things in all the states in India. In the criminal system, public prosecutor rule is very higher. So in appointing the public prosecutor, the political intervention is everywhere. Be it Delhi, be it Assam, be it South, be it North, be it East or be it West. Everywhere the intervention is there. So it should be made independent, and how we can raise our voice. See, for example, every day we are facing, when judge take a case in his hand, he asks the PP what to do. Then why the Supreme Court has appointed you as a judge of the High Court? Why you are asking the PP? PP's role is to what? He has to assist the court, he has to say the status report, what is going in the investigation. But the judges are asking the PP what to do and not to do. We are suffering every day. Number two, sir has rightly pointed out, in appointing and the posting of the OCs, SPs, and all the police, the political intervention is there. The government has to be taken very seriously. Whoever be there in the power, whose party is the power, it doesn't matter. But if you want to serve the country, you want to serve the nation, this system has to be clear. So these are some suggestions we must raise, like appointing of PP, posting of OC and SPs. So another important point, sir, you must be agree with me. Nowadays, there are a lot of new magistrates are coming in judiciary, like AGS, after AGS, third grade. They are freshers. They do not have the basic experience of the courtroom and the trial, but they are directly becoming the judges. So at least this AGS becoming a magistrate, they need 2-3 years of experience. Every law firms, be it Delhi, be it Calcutta, be it Chennai or in Guwahati, when a senior appoints some new lawyer, he asks how many experience you have, how many years of experience. But someone is going to be a magistrate, he doesn't have any experience. So at least 2-3 experience, sir. This is the last, but this because I got the opportunity, and this is I think one of the best forum you have taken such a good initiative for us. So, sir, my questions are to Mr.
Yes,
Khan.
we will
please.
answer.
Okay.
Yes.
Two questions which posed to me. One word answer of first questions. Why we have not able to implement all these reform which suggested by the different committees. My answer is political will. Because whatever we do, ultimately it goes to the politicians. And the politicians, those who, if the system is bad, those who are beneficiary of bad system don't want to change it. So one of the beneficiaries are people who are in power. Hope that things will change, gradually changing, and we, the people, need to raise the voice on many things, which I said, the prosecutors, I don't know why this says may, it should be shall, mandatory district director of prosecution. That's the only thing can improve the system. So political will is required in many things. I can explain in each law, but that's a one word answer, political will. So for second question is concerned, I can't say answer in yes or no. This new 3 law. Many words which are there, almost 70-80% are almost same. So it's what he said, old wine in new bottles, same thing was old thing. But then, there are many places, excellent improvement, what I said. Excellent improvement, search and seizures process, excellent. On the evidence law, the requirement of certifications when the police do search of an electronic record, excellent provisions for protections of the accused or the people who are in the associated case, but it will create challenge for the civil cases. So when the legislature drafted the law, they have thought of criminal cases, but they have not thought of civil cases. I was discussing with someone in the little before the program. Say electronic communications, which are there in a mobile phone and others, when police seized, it's required certification from cyber forensic experts. Police can go to cyber lab, police can get certifications. But the same standard is required for, say, husband and wife as a divorce matter. And there's a communications in the mobile phone where we require to admit a CD or you download from some places. Now we require a same standard of certification. So a private litigant, when they have to go to Center Forensic Science Laboratory or State Forensic Laboratory, they are not accessible. Maybe private lab will be accessible. Maybe some institute will come up which can give certificate, but they will charge. So when they will charge, say one certificate may charge 5,000 rupees, which NFSU is not charging. I heard that they're charging 4,000 to 5,000 rupees per certification. So if a litigant has 4 or 5 digital evidence which requires certification, it's involved expenses. Who will take care of it? So when we make the law, same law applicable to both civil and criminal cases. So there are excellent good things. What I think they should have not done, this what they have done, is if you look at the last section of BNSS and Sakshi Adhiniyam both, they said that any application, proceeding, appeal, trial, etc., pending, then old law apply. Now this will create lots of difficulty. Procedural law can be retrospective, there was no bar. I think they were hesitant in implementing, that's why the government has done. Hopefully the Supreme Court will come up with some judgment where Supreme Court, in exercise of their constitutional power, they can say that all law will apply to old cases. The reason being, criminal cases may dispose of in next 5-7 years. But evidence law, Sakshi Adhiniyam, available for civil cases also. The old civil cases may take another 50 years. So you can't have a system from next 50 years where you'll carry Evidence Act and Sakshi Adhiniyam together in the court. Judges has to refer to 2 books. So that's not practical. The things required to change. So there are many things which they have a scope to improve, they have not done. Many things they unnecessarily burden the systems. Many things there's a good improvement in the law. So I think it's mixture. I can explain the provision, but that's the mix of things.
We have amidst us, we're lucky, thankful that Dr. Debashish Poddar, a professor at NLU, we'll come to him in a minute. So there are some people, some young boys, young girl, who will come to you, sir, a minute.
Good evening. My name is Aditi Kashyap Hajong, and I'm a union member from Handic Girls College. My question is to the respected panel members, and anyone can answer this question. Can measures be taken for crime preventions to start at grassroots level? If so, then how? How can these measures be taken and how can they be implemented? Thank you.
Well, grassroots, I think education, Mr. Bora spoke about it, but if Kutur would like to address, then Mr. Bora can also say.
in my understanding, as I was presenting, the most important element of addressing crime prevention is educating society that this is crime and doing this will have a consequence. That is where it starts. And I personally feel policing in that aspect is very less in our country. We don't get into the education part of it, telling that doing this is wrong and you should refrain from doing it. If you do it, there will be a consequence. That is where addressing it from the grassroots starts. As simple as drunken driving. That is where the whole issue starts.
I think you or I forgot who said, it's not severity of punishment, but surety, you said. So you may like to add? Because as I understand, this is what research says, there is not the threat of death punishment, but even if 7 years punishment is assured or 1 year punishment is assured, crime gets less.
That's true. I'll severity and surety is a general concept. Like if you have a surety of punishment, people are afraid of the jail, even if 1 month jail. Nobody want to go.
You can please sit down.
Yeah. Aditi, one point which I want to say, you can sit down, there is no issue. My area of research is on human trafficking, sex trafficking, and I always say whenever I get opportunity to interact with young students, college students, etc. Today, and I'm giving example from my area of research, sex trafficking. Today, every man of India or every male of India, they decide that they will not purchase a women for sex. Tomorrow, there will not be a single sex trafficking in India. Just think about the same line. So we can achieve the day everyone aware about it and we can take commit that we will not do wrong, then there will not be any wrong. Now, so far educations are concerned, I just wanted to share CBSE in their class 12 course, they have started a law courses. I think state board should also adopt the same thing. Sir can pitch with the government that they can introduce. That could be one of the ways to create awareness among the young students about the law. That could be one of the good ways.
I am going there. Someone raised their hand. Rahul, তুমি নাগিছিলা নেকি হাতখন?
মই সৰু কথা এটা লাইটাৰ ভেইনতে মই প্ৰশ্নটো কৰিব খুজিছোঁ অংশুমান বৰালৈকে যে এনেকুৱা লাগিছে কথাখিনিত আপোনালোকৰ সবৰে কথা শুনিলোঁ শুনি পেলাই এনেকুৱা লাগিছে যে সকলোৱে যেন right from the police to advocate, politicians, judge, সবকে লাগিছে সবেই যেন আইন ভংগ কৰে লটো মিসইউজ কৰে কিন্তু মোৰ প্ৰশ্ন হৈছে কোনে আটাইতকৈ বেছি ল মিস কৰে
মিসইউজ কোনে বেছি কৰে ওকে
মই এটু কেতিয়া ভাবা নাছিলোঁ কোনেও থ্যাংক ইউ ফৰ গিভিং দি অপৰচুনিটি টু থিংক ইন দিস ৱে definitely the stage wise hoyto etu hobo then when the probably the first the misuse koribo the police if they get the opportunity. The second is naturally the lawyers will definitely will try to I'll not say the misuse, I'll say the use. Miss to pisot aibo use koribo janile bahut misuse to belek kotha. If you can use it properly, that's enough. The lawyers knows how to use it rather than misuse it. They know he can't use korbo janile that is sufficient enough. Then the third stage is even I'm not bearing the judges also or the magistrate also. Sometimes they also the same way. It's not there they teloku dhua tulokhi pat nohoy kintu. And the institution is not also the dhua tulokhi pat. Take it for granted. I can vouch for it. No institution is perfect. Nevertheless, the judiciary is also not perfect. But we can expect it because, yes, we have a faith in the judiciary, that's a different issue. That's the only hope for the future, the democracy. But still, there are lots of, that's why the misuse hoi thakibo, jetialeke sobe misuse kori ase, that as far as the concern, my concern is that the appointment also, not only at the point of view of the accused, for the point of view of the victims, the তেওঁলোকৰ প্ৰথম তেওঁলোকক কোনে তেওঁলোকক ইনভেষ্টিগেট কৰে next it comes to the court who defends them, the public prosecutor or the assistant public prosecutor, and what is their expertise also. Who? Do you know? Do you have any idea? Look, again the political bosses. They prepare the list. It will forward it to the deputy commissioner. It will be consulted with the session judge. There's no examination for the appointment of the public prosecutor. Yate brilliant lora bilak nahe kyo, because there is no scope for them. Iman kini lora khuni amar pahakuna lora thake. Bahut pahakuna lora thake. Kinu kiba examination or paddhati yat dise neki. Yate akol ki koi thoise BNS ba agor CRPC to. The experience 7 বছৰ 10 বছৰ experience hole tanoke assistant public prosecutor ba heri hobo pare. But why not an examination? Why not the ei jikhini brilliant ase janoke merit wise tanok kyo agole ahibole khubida to dia nohoy. Jetiai merit wise hobo tetiai tanok bhalke anibo. Tar pisot next proshno to ahe tate aro eta problem ase apnaloke jane thoka ase the monetary expectation. Yat jiti apnaloke asorit hobo ami man dangor kotha kau kintu yate public prosecutor bilake dormoha napai. You know, assistant public prosecutor bilake 3 মাহ 6 মাহ dormoha napai. Jetia 6 মাহ eta lorai dormoha napabo, ejon public prosecutor dormoha napabo, what will happen? Next other option ki ghar cholabor kane. It's very apparent. Next etia hey মোৰ নিচিনা হয়তো উকিলে misuse by use koribo. Again. So that will happen. Jetia town dormoha napabo, definitely 6 মাহ napabo, hoy town sakori eribo. নহয় তেওঁ আন পন্থা ল'বলৈ বাধ্য হ'ব সেইটো কোনে কৰিব সেইটো কৰিব লাগিব সেই যদি দৰমহা নাপায় সো এনেকুৱাবোৰ কথা কিয় দৰমহা দিব নোৱাৰে সেইটো ষ্টেটৰ কথা ষ্টেটৰ ফাণ্ডৰ পৰা কিয় নাযায় আনকি আমি এই যে কথাবোৰ কৈ আছো যে সোনকালে কেছবোৰ শেষ হ'ব লাগে আপোনালোকে আচৰিত হ'ব গোটেই অসমত প্ৰিভেনশ্যন অফ কৰাপশ্যন এক্টৰ আণ্ডাৰত there is only one special court in entire Assam এখন কোৰ্ট আছে. Do you know? Ekhon court gute Ahomor case Guwahati ekhon court handle kori ase. There are not even a second judge. Okol ejon judge ekhon court, special court. Ar teloke ki decide kori ase sobot ke dangor case bo jibur prevention of corruption or under hoye ase sobot ke manu affected hoye ase. Prevention of corruption cases are most affected. Hokolu manor fabric of the society is affected. Jetia eta prevention corruption or case ahe. এটা সাধাৰণ মাৰপিটৰ কেছে দুজন মানুহৰ মাজত হ'ব চিটিংৰ দুজন মানুহৰ মাজত হ'ব যেতিয়া এজন এনেকুৱা আমি যেতিয়া ডাঙৰ কেছবোৰ স্ক্যামৰ কথা কম হাজাৰ মানুহ এফেক্টেড হয় সেইবোৰ বিচাৰ কোৰ্ট হৈ আছে there is only one court there is not even second court that's the irony আৰু তাতে কি হয় আমি ইয়াতে কৈছো স্পিডি প্ৰসিডিউৰ সোনকালে শেষ কৰিব লাগে সোনকালে চাৰ্জ ফ্ৰেম কৰিব লাগে সোনকালে কিন্তু ইনভেষ্টিগেশ্যনৰ কাৰণে কিবা টাইম ফ্ৰেম আছে নেকি 90 days 60 days is not the mandatory period 90 days বা 60 দিনত শেষ কৰিব লাগে এটা ইনভেষ্টিগেশ্যন বাট ইট ইজ নট মেণ্ডেটৰী অলৱেজ সুপ্ৰিম কোৰ্টে এইটো ক্ষেত্ৰত কিন্তু কোৱা নাই তেওঁলোকে নতুন আইনত কোৱা নাই যে ইনভেষ্টিগেশ্যন ইমান দিনত তোমালোকে শেষ কৰিবই লাগিব কেতিয়াবা পচিবল নহ'ব পাৰে দ্যাটছ এ ডিফাৰেণ্ট ইছ্যু কিন্তু পাৰ্মিশ্যন লৈ পেলাই কি ধৰণে শেষ কৰিব লাগিব এই বিষয়ে কোনো নকলে কিয় অকল স্পিডি ট্ৰায়েলৰ যে চাৰ্জৰ কথা দ্যাটছ এ ডিফাৰেণ্ট বহুত পিছত আহিব প্ৰথমতে স্পিডি ইনভেষ্টিগেশ্যনটো হ'ব লাগিব স্পিডি ইনভেষ্টিগেশ্যনৰ ক্ষেত্ৰত তোমালোকে কি কৰিলা 14 days টাইম আকৌ বঢ়াইহে দিলা These are the dichotomy. Thank you.
Good evening, sir. Myself, Bonujjal Gogoi. I'm a third year MBBS student from Gauhati Medical College. So let's suppose that I am a surgeon, and while operating a patient, due to some mistakes on the OT table, my patient died, and the family members sued me for this. So what do you have to say on this case, because human errors do occur?
There are lots of judgment, nothing to be worried, unless and until you, first of all, you have to find out a good lawyer. And you must have to pay payment korbo karone tumar paisa to jodi tumar ase, you can afford it. There is no option. Then you are unsure about your safety. But the law is that your negligence, it's a case of a negligence. Tumar negligence to sabo. And negligence is not a general negligence, which has to be gross negligence on your part, and it will be decided not by the lawyers. First, there will be a committee will decide that tomorrow to not gross violence, there will be a committee of the doctors, not by the lawyers, don't worry about it. They will decide it's a gross violation or not. If it is a gross violence, then only then the FIR can be registered.
Yeah, good evening, everyone. My name is Anisul Haq, and I almost looked a lawyer today had it not been for my T-shirt. So, in fact, my name is Anisul, like as I said, and I'm a brand and communication consultant. And today I'm here, I think I'm the black sheep here. So, I have no question actually, just one or two observations that I have as someone who's in communication and human behavior. I think what lacks primarily is intent, as this is what actually came up after all this discussion so far. In every step, if you have the right intent by the right person, I think a lot of good things always get done. And intent comes from the quality of thinking, quality of a human being. Whatever stage of life one is, or whatever department, you are a policeman, or you are a lawyer, bureaucrat, or even a normal human being too. So I think what we need to understand is that whatever, how much we discuss about all these things is like a vicious circle. We will come back to a certain point where we'll always come back to square one, no matter how much we discuss. Even this seminar, it winds up, we have our dinner and go back, come tomorrow, the whole business starts afresh and it goes on like that. If we look ahead probably 20 years plus from now onwards, I think we can see some changes definitely. How? The only way I think to bring about change is to have an academic angle, because the organizers have academic connections here. So I think it's also relevant to say the only change that can happen is by imbibing some qualities in our children right from now onwards. Because it's not enough to tell them that this is right, this is wrong, this is ethical, this is unethical. I think what is righteousness, one of the most important things for a human being to be actually bracketed as good, is not something which you normally talk about. What is the premium you attach to being righteous always? Justice being something that you should always be careful about. And we should tell children that when you grow up, you become a good human being. And you get a lot of things in return. Why are we not ambitious to become greater human? Because we don't see much of a return in that. We see a lot of return, maybe financial, maybe fame-wise, whatever, because we tend to go off track, do some things which are not ethical, not moral. But if we tell them that if you start giving in life, you get so much in return. Because I'll just wind up, because it's a very normal human nature that when you get something, you always give back. So if children are being imbibed with such qualities, I think we are going to have a really, really good future after a few years. Talking about what possibly we can do, few things now onwards, is that, today on social media, we've got a lot of great content, despite social media being bracketed as something which is very harmful. But harmful is what we make of it, good is what we make of it. We have got a lot of good content on health, a lot of good content on business and entrepreneurship and all this. But what about some legal issues? I think I'll request lawyers like you who are so proficient and good communicators too. You should come up with capsule-wise things where legal things are made easy for common people to understand. Make reels, make great content. People will know, they have become aware of their legal rights and everything. So I think these are things you can do. School, I think the very fresh air came in the form of Assam school, the whatever board you call it right now. They have come out with a financial literacy for the students also. In the course curriculum is being included. Why not, as we already discussed, some legal issues or knowledge and learnings to be included in the children. And I think this is what I can tell. A lot of things to be told, but excellent forum, good things, good show to be part of, and thank you so much.
মোৰ নাম আলামিন হক, মই বৰপেটা বাগবৰৰ পৰা আহিছোঁ। আমাৰ মন্দিয়া আউটপোষ্টত যোৱা 23 এপ্ৰিলত, এই 2024 চনৰ 23 এপ্ৰিলত এটা কাষ্টডিয়েল ডেথ হৈছিলে। সত্ৰকুনাৰা বজাৰৰ পৰা এজন উদীয়মান যুৱকজনৰ 28 বছৰ বয়স আছিলে। মন্দিয়া থানাত অনাৰ ঠিক 1.5 ঘণ্টা পিছতে তেখেতসকল ক'লে যে চিপ লৈ আত্মহত্যা কৰিছে। তো এই আত্মহত্যাৰ ক্ষেত্ৰত তো কেনেধৰণে ভুক্তভোগী পৰিয়ালটোক কিবা ন্যায়িক সহায় কৰিব পাৰি, আৰু চৰকাৰৰ ফালৰ পৰা বা ন্যায়িক তদন্তৰ ফালৰ পৰা সেই ভুক্তভোগী পৰিয়ালটোক আৰ্থিকভাৱে অনুদান আগবঢ়াব পাৰে নেকি? এই ক্ষেত্ৰত মই শ্ৰদ্ধাৰ আংশুমান বৰা ছাৰলৈ অলপ সঁহাৰি এডভাইচ বিচাৰিছোঁ।
মানে কি ক'ব খুজিছা তুমি?
কাষ্টডিয়েল ডেথ মোৰ ঘৰৰ ওচৰতে মন্দিয়া আউটপোষ্টত 2024 চনৰ 23 এপ্ৰিল তাৰিখে
Custodial death hole.
হয়
Now,
তো ঢুকাইছে এতিয়া সেই পৰিয়ালটো ভুক্তভোগী পৰিয়ালটোক
naturally, for the custodial, and always you can approach directly to the High Court under 226 for the compensation. There is a provision for that. তোমালোকে নিজে যাব পাৰা আহিব পাৰা হাই কোৰ্টত তেওঁলোকৰ ভিক্টিম তোমাৰ পৰিয়ালে they can approach the High Court for the compensation and state is bound. There is a provision, there is a slab has been incorporated কোনটো কেছত কিমান দিব up to 5 lakhs initial compensation লৈকে দিয়াৰ provision আছে in the High Court itself. There is a provision itself.
Good evening, honorable panelists of today's discussion. So, my question is that, first of all, in 2006, the Supreme Court of India passed the landmark judgment of Prakash Singh versus the Union of India, where it outlines several guidelines for police reforms in the states and union territories, and in order to ensure transparency and accountability and to prevent political adherence. So now, coming to our own state, Assam, between 2000, in the previous 5 financial years, as per the NHRC report, there has been about 28 custodial deaths. And other than that, between May 2021 to August 2022, there has been over 171 police encounter. And one of the instances is the encounter of Abdul Kalam Azad in the Karimganj district, where the police came up with a statement that the accused, he tried to escape from police custody, because of which the police tried to encounter him in self-defense. So my 3 questions are, number 1, that first of all, how the state of Assam, how the Assam police has been able to comply with the guidelines that was set by the judgment of Prakash Singh. Second question is that is it necessary for the police system or the police authorities in Assam to use lethal force against the accused who are in custody? Like, the question is that আমাৰ অসমৰ পুলিচসকলে অকল কপালত বা মূৰত বা বুকুতে গুলিটো কিয় মাৰে, ভৰিত বা কি কয় আঁঠুত মাৰি পেলাই কি কয় যোন পলাব খুজিছে তেওঁলোকক ৰখাব কিয় নোৱাৰে? কাৰণ when they try to shoot in the head or in some other important part of the body, it ultimately leads to the death. And the third question is that আমাৰ অসম পুলিচ ইমানেই দুৰ্বল হৈ গৈছে নেকি যে যেতিয়া কাষ্টাডিত এজন একিউজ থাকে, then সেই একিউজজনে কাষ্টাডিত পুলিচৰ পৰা ৱেপন স্নেচ কৰি পেলাই কাষ্টাডিত ইমান পুলিচ থকাৰ মাজৰ পৰা পলাইছে, because of which the police has to encounter them, and that too because of self-defense. So these are the 3 questions that I want to raise.
Okay. I'll pass the question to Professor Khan. However, to set the context, because it is Assam and part of it were Assamese, Prakash Singh kesot Prakash Singhe nije Times of India likhisile. He wrote in Times of India himself several years back after 2006. He wrote himself in that Times of India column that almost all states are in contempt of the Supreme Court order. So the first point was that the operation of the police will be done by a committee. And in our Assam Act, new act, that thing was removed. So, yeah. So I think you have understood the question. He has got 3 things. Why the police, why police are so weak that a person under arrest can escape? First question. If they escape, why are they shot to death even?
Okay, very difficult questions in the sense that it is illegal, it is death, it is murder, but it's happening. Why police do? Maybe societal pressure that we want remedy, immediate remedy. So justice. So immediate Ganga Jal, whatever different film we see. So they want, this is the best mechanisms in which eliminate the criminal. Now without proving they are criminal. So any kinds of these kinds of action amounted to homicide. It's a murder. Undoubtedly. Now question is how you'll prosecute, etc. It's a different questions altogether. When a person's run away from police custody, police has power to arrest. It is also true that when police want to arrest someone, law says, it was earlier section 46 of the CRPC, now the section number in BNSS, it is something nearby, 48 or so, where it says that police can use force and then says it cannot use force to kill someone unless a person is accused of death or life imprisonment. Impliedly, if someone is accused of death or life imprisonment, police can kill them also. Then, but question comes, any police action or any legal action should be proportionate. So question was, any circumstances when police use force, was that force necessary at that point of time? If not, then it is murder. Or culpable homicide, not amount to murder, depending on the situation. How to change it, these situations? The only way to change is to prosecute them. Have a law says, law is very clear. Law says if there is a custodial death, instantly immediate inquiry has to be done by judicial magistrate. Many times they avoid it. They write it something as X, Y, Z, not custodial death. So he was not in my custody. They don't want to show as a custody. As soon as it becomes custody, law says there should be judicial inquiry. It's a mandatory judicial inquiry. Many things can come up. And when it's a judicial inquiry, that means judicial magistrate will be there. When it is judicial magistrate, they are more accessible and we can believe they are more independent. They are not prone to the government or prone to the police. So many facts can be brought in there. But then we see cases, Shakil Abdul Ghaffar Khan cases, where for registering FIR, people has to run from pillar to post. Basic law is it has to be done, there should be judicial inquiry. Basic law is there must be FIR against the police officers. And then if the police officer is FIR, then police officer has to justify, or if the police is to find whether it's a really right to private defense or not. So for right to private defense is concerned, all of us has, so police has. We all have right to private defense, and in exercise of our right to private defense, we can kill someone, law permit it. So when law permit us, law permit to police also. So there's no doubt about it. But was it really right to private defense? Or it is excessive use of force to give some instant justice? If it is excessive use of force to instant justice which is not proportionate, it is amounted to murder, and we should voice for starting cases against them. The day we start starting cases, you will find that things will change if the convictions can start. So it can only happen when people can be more aware and start cases. There are examples when many police officers got convicted also. In West Bengal, in one of the cases when the Punjab insurgency was there, Punjab police came to Calcutta, they killed one, took the dead body to airport, and from airport they ran away to Punjab. One of the lawyer, they file a writ in the Calcutta High Court. High Court directed for CBI investigation. And CBI submitted charge sheet against all those 5 police personnel. All of them got convicted. The day we start taking some actions against the lawful, these kinds of police officers, the things may change. That's the only way out.
Encounter killing.
It's a murder. We encounter. Encounter is a murder. Police is doing murder. So suppose if I do murder, there should be a FIR. Answer is yes. When police do murder, there should be a FIR. There is no doubt about it. So we can't say that if it is encounter, things become decreased. It's a murder. Anything which is extrajudicial killing are a murder, nothing else. So there must be prosecution for murder for those officers.
Unless there is some objection, I need to extend the time by 15 minutes because there are some gentlemen who would like to ask question. So one, the last question would be Professor Poddar's. There is one person who raised his hand there. 2, 1, 2, any more? 3. Timir, okay. Mitra, 4. 4 questions, 5 questions. Okay, 5 questions. Yes.
So first of all, today's session is very eye-opening for me because as a general public, sometimes when there is a injustice, we always blame the police and the lawyer. Today came to know that there is some more power above you. My question is little bit different. As Pankaj sir said, the first sentence Pankaj sir said in the session that if there is a less demand, there is a less supply. So if we need a crystalline clear justice, like we have seen in the crime patrol, so we have to create the more demand from the public. So whenever we think about the creating the demand of justice, we see there is only one way, it is a protesting. By lighting a lamp, candle, by shouting in the road, Murdabad, Murdabad. I just want to know, is there the only one way to creating the demand of justice? only the protesting, or is there anything other else so that I can do from my home without coming to the road? Is there any intelligent way so that my message go to the Supreme Court? Or is only the one way to do shouting like that? Because protesting is nowadays is some political party there, some association there, they are actually promoting themselves by being protected.
Yeah, hijacking the protest.
Exactly.
Okay, thank you so much. So I will pass your question to Saikia sir. Apuni, would you like to answer?
Protestor bahire baki to moi janat one person can directly write to Chief Justice of India. Chief Justice of India direct চিঠি লিখিব পাৰা চিঠি হিচাপত তুমি কেছ কৰিবলৈ যদি অসুবিধা হয় চিঠি হিচাপত লিখিব পাৰা তুমি আৰু তোমালোক ডেকা ল'ৰা ছ'চিয়েল মিডিয়া আছে ছ'চিয়েল মিডিয়া আছে ইনষ্টাগ্ৰাম আছে ফেচবুক আছে দেয়াৰ আৰ so many ways.
আৰু এটা হ'ল যে আমি আমাৰ ৰিপ্ৰেজেণ্টেটিভবিলাকৰ ছাৰে যিটো খান ছাৰে যিটো কৈছে যে উই কেন আস্ক আৱাৰ ৰিপ্ৰেজেণ্ট নেক্সট টাইম যেতিয়া আমাক কোনোবাই ভোট খুজিব আহিব আমি তেওঁলোকক প্ৰশ্ন সুধিব পাৰোঁ চ' য়েছ দ্য নেক্সট পাৰ্চন হুএভাৰ য়েছ
Good evening, everyone. My name is Sarfaraz Ahmed Khan. I'm an advocate in Gauhati High Court. Angshuman sir has already answered most of the queries which I had. But I have a very specific query to Dr. Khan regarding this enactment of the BNSS vis-a-vis CRPC. What, in your opinion, is the biggest miss on the part of the Indian legislature while enacting BNSS compared to CRPC? What is the biggest miss?
Many things. For example, I said already right to speedy trial is missing. Victims' participations missing is not there in the processes. Even the restorative justice kinds of things that could have been incorporated there. Compensations like witness protection scheme. It says the state will make the scheme. We know how the state will make a scheme and when they make a scheme. So it may take another 10-20 years that the state to make the scheme. They should have pointed out specific things for there. One new thing was born basically in the Nolakha case, where the Supreme Court has Mr. Nolakha, he given him house arrest. In Calcutta also, one of the cases they have given house arrest. Before even the child could have born, this new law has make date of it. It says that the custody means only police custody or judicial custody. There is nothing called third custody. So this now house arrest concept which could have taken place might be that its scope has gone. So in that way, many places they have missed in the BNSS.
Big ones. Big ones. I hope that answers your question. Yes, sir.
Yeah. Just supplementary of my previous question that, sorry, I'm Nayanjiti here. I'm working with Action 8 in Guwahati. So this is not a question, but it's a concern for, I think, for all the Indians that we have on constitutions. So do you feel that these three laws, that BNS laws, and it has properly addressed the basic structure of our constitution, the basic spirit of our constitutions? What is your observation as academics or Angshuman Bora as a lawyers?
I think that question has been already answered, but do you have any specific concern?
Yeah, that is, the concern is that there's a big debate of the Kesavananda Bharati case also. There's 2 points. One is the human rights and the rule of law. Do you feel that these 3 laws has rightly addressed that spirit and the basic structure? Thank you.
There's one provision in the, regarding the power, the new enactment which has been brought, there's several powers given to the police. So I think the new act has given some more power to the police. Some may be good, some may not be good, but I think some powers for the most important powers given to the police is the period of the custody. Agote ki asile custody labor karone police within 15 days or they can take a custody of a person. Within first production or within 15 days they can take a custody of a person. Now it has been increased, not 15 days, either 15 days now they can break it into up to the 40 days or like they can take a custody of a police. 40 or sometimes it is 60 depending on the punishment of the particular offense where he's been charged. So that is the power has been given to the police for taking the custody. So because of that power, now it will definitely will hamper the bail applications. Bail applications now that the police can come up or the public prosecutor can come up after 15 days also that we have not taken him for the custody. I mean, only we have taken him for the 2 days custody. We want more custody. After 15 days also, now they can come up with this kind of ploy to delay the bail application. So Eturkane now, that will create a problem. Now, the Supreme Court always saying that the bail is the principle, jail is the exception. So where now under this provision that is the new or this new provision has been brought in, it will definitely conflict. It will power police dia hol. Jitu taloko custody lobor kane khubida kori dia hol. So it moi bhabu je human rights or khetrot it's a definitely at a concrete area conflict at a system in future time. Then again kismaitia agote এটা provision asile the custody period to taloke 10 years or jibur punishment asile agote mandatory 10 years to 60 days ot paisile কিন্তু এটু আজিকালি 90 days কৰি দিয়া হল 10 years of punishment or ক্ষেত্ৰত সো তেনেকুৱা কেও কিছুমান তেওঁলোকক অত্যাধিক পাৱাৰ দিয়া হৈছে দেন দি সার্চ এন্ড সিজাৰৰ ক্ষেত্ৰত ইমমুভেবল প্ৰপাৰ্টি ক্ষেত্ৰতো তেওঁলোকক অত্যাধিক পাৱাৰ দিয়া হৈছে সো এই যিখিনি পাৱাৰ দিয়া হৈছে দেয়াৰ ইজ এ চান্সেস অফ মিসইউজ তাৰে কিন্তু প্ৰটেকশনটো তেওঁলোকে প্ৰভাইড কৰা নাই ইন দিস নিউ বিএনএছএছত হে প্ৰটেকশনটো নাই অনলি ইয়াৰে হেৰিপুৰে আই থিংক দ্যাট দি ইন ডিউ কোর্স অফ টাইম there will be a Supreme Court judgment. I'm hoping so for the protection in this kind of situation. Jot enukwa dhৰণৰ ঘটনাবোৰ হ'ব পাৰে. So এই নতুন এক কিখনে মই ভাবো যে সাংঘাতিক একো এৰিও নাই বৰঞ্চ কিছুমান অত্যাধিক পাৱাৰ হে পুলিচৰ হাতত দিয়া হৈছে কিন্তু মই ভাবিছো যে এই পাৱাৰখিনি নোহোৱাকেও প্ৰপাৰলি ইনভেষ্টিগেশ্যন কৰিব পাৰিলহেঁতেন আমি মই এটা কথা আপোনালোকক ক'ব খুজো দ্যাট ইজ মাই এক্সপিৰিয়েঞ্চ শ্বেয়াৰিং ইট যে আমাৰ ইমানবোৰ কেছ হয় আমি দেখো পেপাৰত বিশেষকৈ দি ট্ৰ্যাপ কেसेस where the people has been caught red-handed while taking the bribe. Every day you will find out in the newspaper that someone has been caught red-handed while taking the bribe, raising hands. But actually, bribe luatu komiseneki. Is there any decrease? Even though there is so many arrests, why there is no decrease at all? এটো আমি চিন্তা কৰিব সরকারে ভাবিছে হয় সৰু সৰু মানুহবিলাকক ধৰিম 5000 10000 টকা লৈছে they have been arrested caught red-handed. I'm not saying about the CBI person recently arrested 60 lakhs. I'm not on that. But some people are arrested for taking 5,000, 10,000, 20,000 money. They have been prosecuted for taking. But the etur khetrat kintu crime to decrease one eye day by day increase hoi goi ase kyo ৰেপৰ ক্ষেত্ৰত we have increased the punishment death হলেকে গুছি গলো ফলত কি হল তাৰ ফলস্বৰূপে কি হল যেতিয়াই মানুহে দেখিলে যে there is a possibility of death penalty after the committing the rape victimক মাৰি পেলোৱা হল তাৰ আগতে victimক নামাৰিছিল হয়তো কি কাৰণে মাৰি পেলালে because tomorrow there is a possibility that she may identify the accused so যেতিয়াই the punishment has been increased তার এটা উল্টা রিভার্স এফেক্ট এটা হল যে যদি ভিকটিম জনিক লগে রেপ কৰিলো দেন মাৰি পেলাইছো তেতিয়া there is no chances of identification because there is a severe punishment has been prescribed brought in similarly আমাৰ ইয়াতো দেখা হৈছে ইমান মানুহ সদায় ধৰি থকা হৈছে ভৰিত গুলি আইছে ঠিক আছে ভৰিত গুলি আইছে ড্ৰাগ ডিলাৰক ভৰিত দিলাইছে ড্ৰাগছ খোৱাটো কমিছে নেকি কোবা ড্ৰাগছৰ প্ৰচলন কমিছে নেকি কিয় কমা নাই আমি সেই দিশত চিন্তা কৰিছো নেকি যে ইমান ভৰিতটো গুলিয়ালে হেতু সময়ত যেতিয়া ড্ৰাগছ ধৰিলে so many people so many peddlers has been caught হিয়তক ৰাতি পলাই যোৱা বুলি so many ভৰিত গুলিয়ালে তাৰ ফলত ড্ৰাগছ পেডলিং কমিছে নে ড্ৰাগৰ সৰবৰাহ কমিছে কি কাৰণে কমা নাই ইয়াৰ গুৰিটো ক'ত এই গুৰিটো যেতিয়ালৈকে আমি আসলতে গৈ নাপাওঁ আই থিংক these are all the superficial exercise
তিমিৰ কোৱা
Good evening, everyone. More प्रश्न इटू आसिले आपनालोकले जे आपनालोके भाबे नेकी जे there is a political unwillingness to reform the India's criminal justice system because as I feel that people in power, they want to maintain the status quo, so that because the first people that will be behind the bars, if the reform is made, that would be the politicians who are in charge of reforming the India's criminal justice system. Thank you.
That is the issue. It is not just the politician, it is also the beneficiaries of the entire system. See, it is a very simple thing to blame a politician because we can see him day in and day out. But there are so many beneficiaries in the system who are connected to the politician. The questions are larger than a politician. The question is, how are we structuring ourselves as a society? That is where the buck stops. Unless we address that, the larger question will not be addressed.
Anyone would like to be more specific than this?
With reference to pinpointing it to politician, that is not the solution according to me. According to me, the solution lies in addressing this issue of judicial reforms in a more structured manner, that is fixing smaller issues. One, fixing issues like which are more doable issues rather than addressing larger issues. As sir was saying, fixing the issue of service of summons. How can we fix service of summons? Break it down into different pieces. There might be 10 different pieces where you address one piece at a time. That would make the system more efficient.
Okay, then this is the last question.
I am here as a learner. It's a learning experience. And I learned many things because I am not a criminal law person, but not criminal law. So it's a learning experience. As a layman in criminal law, and also I studied criminal law, a student of criminal law. Sometimes, off and on, I researched on this segment also. A few questions which is still unresolved because I'm not a criminal law researcher. 1, 2, 3, very quick point. This is nothing to answer. If the speakers answer, I'll be happy. But rather than answering, let us take it as a takeaway from this session that with mixed opinion, we have reformed criminal legal system. But what about reform about criminal legal tradition? That is, by British legacy, we are following the common law system, common law tradition. So here I'm distinguishing between legal system and legal tradition. By legal tradition, I'm mentioning common law tradition. Besides, there are other traditions. In number of tribal traditions are there, but civil law tradition is there, which governs the entire Europe, which governs the 75% roughly of the world population. So is there any space for improvement in this legal tradition? Or is there any space to experiment something else like civil law tradition or our own indigenous legal tradition? Because before British era, before British India, there was no common law tradition. So, already by and large, there is the public perception that common law tradition failed. Common law tradition failed miserably. So legal system is getting reformed, but what about reform in legal tradition? This is one. In this, after this reform, is there any answer to this very fundamental question that who will police the police? So this is just a takeaway from this session. And also, in the criminal justice system, as it is written here rightly, another very important pillar is prison. So the way incarceration is happening, there was one question, I got it from internet source, that once President APJ Abdul Kalam raised this question to Correctional Home Department, that why most of the prisoners, roughly 90% are poorest of the poor. And President of India is asking. And there was no answer. during his presidential position, he was not answered by his own department, Correctional Home Department. So prison system also needs reform, whether or how far, but it is very important pillar of criminal justice system. So this one, there are three pillars in my question. One is the legal tradition. What about reforming legal tradition, or if there is space for experiment with legal tradition? That is supplanting, not supplementing, supplanting the entire legal tradition, because it is not of our own. We had our indigenous tradition, which we left, which we forgot also. Also, as per global best practices, 75% of the global population is governed by the civil law tradition, which believes in inquisitorial mode of litigation, etc. So second pillar is who will police the police, because this is a very fundamental question, whether there is any answer in this legal reform. Third, and that is also important to me, that what about the prison reform? Thank you.
Thank you so much, sir. We are lucky to have you as one of the audience members, and he has given some key inputs. Now I will wrap up and we'll skip the vote of thanks. I will do it here. So hopefully, give me a few minutes to wrap up. As I told you, India Policy Institute's aim is to bring researchers, that is academics and practitioners, with the quintessential Aam Janta. Luckily for us, we have got more than Aam Janta, lots of practitioners here, some students, some student union leaders. So what we hoped, I hope we have achieved it, is that many of you here, some Rabha Council members are here, so practicing politicians are here. So we would have made you aware about the issues so that as opinion makers, you can go to the grassroots, real grassroots. I know the Rabha Council, it operates in the real border areas where there are no internet connections even. So I hope this message will be spread, and this main question that who will police the police, or in other words, who will bell the cat? So that will be answered. It's a vicious cycle. It's a vicious cycle, really. But this vicious cycle has to be broken. And things do change. Things change. In the villages, there were no, 5 villages. In Guwahati, there were no telephone. And today we carry 2-3 mobile phones. So this, some reforms are required. And unfortunately, reforms had happened. For example, 91 reforms happened when India had to pawn its gold. Yashwant Sinha has written, he had to carry the gold. And today, with all this misfortune, things are coming up. And all the panelists have spoken. Mr. Kutur has said about autonomy of police. And he had addressed one question which there is no time, because hopefully if we go to colleges, we will be able to talk about it. Why confessions under police is not to be believed. Why? Why that protection is there? Saikia sir has spoken about his own experiences. He has rightly said that police officers, if they are really honest, they can withstand police pressure, but it's really difficult. Having said that, it's really difficult. His own thing, he's explained. There is a big systemic system behind politicians. To Timir's question, what Mr. Putur said. Professor Khan has spoken about all the, one main thing, it has struck me so hard when she said victim rehabilitation. I remember one young fellow in Bangalore, he was a IT personnel. He was about to go to Australia to join a job. And there was a threat to the President of India from a mobile connection. The mobile company identified him, that it is his mobile from which threat was given. He was arrested. And immediately, as he was arrested as a terrorist, his visa got cancelled. After a week, the telephone company said, oh, we made a mistake. It was not his number, it was another's number. But by that time, his life was gone, destroyed. P. Chidambaram came out with a policy of rehabilitating such people. He did this scheme, but it was never implemented. That never happened. So that is not only one case, there have been hundreds of such cases. Angshuman has rightly said about prosecutor, PP, the real picture, being a practitioner and a senior advocate of Gauhati High Court. And from the questions and words of support from the practicing lawyers, I understand he has touched a raw nerve. Rostering, yes, there's a very big issue. I once saw a podcast. And appointment of judges and all that. So I hope there will be lots of food for thought. And to the main question that who will police the police, that Dr. Khan has said, that it's political will. Timir brought up the question. So we will have to answer, we are the citizens of India, for whom the bell tolls. For whom the bell tolls. The bell tolls for you. Whoever can hear, the bell tolls for you. And with this, I thank everyone. I thank for your patience. It's 9:24 now. We have taken extra 24 minutes. Thank you for your patience. Please have dinner. Thank you.